Good morning, ladies and gentlemen. I wonder if we might do something radical and actually start a little early. But are the reporters, are you set? Ready? Okay. Interpreters, I can't see the interpreters. Are we okay with the interpreters? I can't see through the... We're good on interpreters? All right. Who do we have remotely? Do we have, Luisa, we have Ottawa remotely, and I guess we have some people in Lima remotely. Can we determine if they're online?
Sir, I understand that the non-disputing party is connected remotely. I am not sure who else from each party's side is connected right now.
Okay, well, if they have difficulties, they will presumably let us know. I assume you're all familiar with the mic procedure here. If you're speaking, turn it on. If you're not, turn it off. We will be doing a good deal of work through interpreters, so we will need to speak slowly and distinctly and hopefully with clarity. I see we have our new drives here. Thank you very much for those whose evenings were ruined having to do those. We do appreciate it, and so that we can have access to these new translations. Luisa, any other administrative business we need to tend to at this point? Are we set?
No, Mr. President, just you made the note about the microphones, and not only when you're in the hearing room, but when you leave the hearing room, just make sure they're off. And if you're speaking to your neighbor, also make sure your microphone is off, because the microphones will pick up whatever you say, and that will go in the recording. So, just a reminder.
All right. Well, I think you all know who we are, and perhaps at this point we could go on the record and formally open this hearing, and I will then invite each party to identify those who will have speaking roles with us this morning. So let us open this hearing in ICSID case ARB/20/46, Lupaka Gold Corporation versus the Republic of Peru. The panel has done a good deal of preparation and consultation, but we do look forward to hearing from you. I wonder if we've got big teams here, and I don't know that we need to introduce everybody, but I wonder if we could get on the record sort of who's going to be doing the speaking, beginning with the claimants. Over to you, sir.
Thank you very much. Good morning, members of the tribunal. I am Jaime Gallego. Next to me is Mark Veit. After that is Mr. Tim Foden, and after that is Luis Miguel Velarde Safel. They will be doing the speaking.
All right.
At the end is Mr. Gordon Ellis.
We greet you and greet the other members of your team as well. All right, and on the respondent side.
Good morning, Mr. President, members of the tribunal, esteemed colleagues. My name is Patricio Grané on behalf of the Republic of Peru. Next to me, Ms. Vanessa Rivas Plata, the President of the Special Commission that represents Peru in investment arbitration. To my left, my partner, Paolo Virosa. To his left, Timothy Smythe. And to his left, Mr. Brian Bombasaro. All of us will be having speaking roles today.
Oh, very good. We look forward to working with you, and we greet all of the others on your team. But I think if, in the interest of time, perhaps you'll forgive us for not introducing everybody. We perhaps come back and get the rest of you tomorrow. But, all right. Now, in terms of procedure today, I think we indicated that for medical reasons, it may be necessary for us occasionally to take brief breaks. We have built in time for that in the schedule. We will just see how that goes, but we would appreciate your understanding and forbearance if that may be something that we need to do. Now, let me ask from either side, are there any more administrative matters we need to tend to? Claimants, anything on your side?
Yes, sir, just a few points.
All right.
As to the witnesses, it would be convenient if they are ready at least one slot before to testify. We see that there is a distinct possibility that Mr. Saavedra may be needed one slot before. So that would mean that he possibly could testify on Thursday night. We just flag it so that
Yeah.
he be
On
available.
that, I guess we would encourage the parties to work that out as best you can before you come to us to sort it out, but you will keep in contact on that, I'm sure.
Okay. Thank you, sir. For our opening statement, we may be slightly longer for the first bit. It's split in two parts, around an hour 40 we've seen, and slightly therefore shorter for the
I
second
think, yeah,
part.
I think the odds will be that we will probably interrupt your first bit if it's that long, but we'll see how that goes.
Okay. I also wanted to raise that Mr. Bravo obviously will be testifying in English. His English is good, but it's not his mother tongue. Therefore, if he really needs to, he may speak in Spanish with the help of the interpreters now and again. He doesn't intend to do it throughout, obviously, but he may need that.
All right, but we'll do what we need to do.
Okay. And as to Mr. Retuerto, he will be cross-examined remotely, as we know. We're concerned about the technical difficulties that have been raised by the respondent. We'd just like to know if these have been fixed, and then if they have been fixed, well then it's been sorted. But we'd just like an update on that.
Okay, anything further on claimant's side?
For the moment, that's it. Thank you.
All right, thank you, sir. On respondent side?
Thank you, Mr. President. A couple of housekeeping issues. They do not pertain to the opening, so I'm happy to address them now.
Let's do it now.
Perfect. The first issue concerns the number of bundles. PO6, Section 23 calls for 12 copies. We understand that the court reporters do not require their 2 hard copies, and we understand that the interpreters, instead of 3 copies, would only need 2. With the tribunal's indulgence, we would request, therefore, that we reduce the number of bundles that may be used so that we don't kill as many trees.
I'm all for not killing excessive trees. I see a positive reaction from the reporters, and I trust we'll get the same from the interpreters. So if that is the case, that's fine.
Thank you.
Kill fewer
Therefore-
trees.
Thank you. Therefore, we will prepare only 9 copies instead of 12. The second issue concerns experts. We have approached opposing counsel to suggest that experts be allowed to bring in their notes with them, both on the presentation and their expert reports. As the tribunal knows, that's not unusual, and that is the request that we put to the tribunal. Obviously, fact witnesses will not be allowed to bring anything into the room, but again, experts tend to be different in this respect. So that's our request.
Right, but we'll revert to that, but are there any other administrative things you want to raise? Or should we
I can respond to the question from opposing counsel as to Mr. Retuerto.
Oh, okay, well, let's do the question of experts bringing in their supporting material. Claimant's view on that is?
Thank you, Mr. President. Our view on that is that it's slightly troubling that they need their notes. Speaking notes, of course, are fine, but anything else than that we don't think is appropriate. If there is an insistence for them to have their own notes, then they should be shared with us.
Perhaps I don't understand the issue. I thought the issue was that the experts wanted to bring in their whatever supporting materials, reports, matters of that kind that they referred to in their reports. Is that what we're talking about, or are we talking about something different?
No, that's correct. But in preparation for their presentation and their cross-examination, experts usually will make notes on the margins of their reports, and we are requesting that experts be allowed, again, in conformity with not unusual practice in investment arbitration.
Okay.
But having said that, we would object to the proposal from the other side that those expert notes be shared with the other side before their presentation.
May I make a comment?
Please.
If the experts' presentations are going to take the form of PowerPoint presentations, the PowerPoint presentations are themselves a guide to what the expert is going to say. So that would obviate the notes. If the notes take the form of aiding the expert in the cross-examination, I don't think they are appropriate. That's my own view. It's not the tribunal's view. That's my own view. So
All
one
right.
thing is notes that are in aid of the initial presentation in lieu of direct examination, which I can understand that are useful unless the expert uses a PowerPoint presentation, in which case they are not necessary. But I don't think that notes for cross-examination I don't think that they are appropriate.
Mr. Chairman, on the transcript, I have the honour of appearing for the present speaker.
I'm sorry.
That is true. We need to get the arbitrator sorted out. Okay. All right, we will attribute the appropriate comments to the appropriate arbitrator. Let me just see if I understand clearly what the issue is here. As I understand it, the experts will have prepared their reports on the basis of books, reports by others. They will, in all likelihood, have annotated those with their personal notes. And the issue is whether they can bring in those reports with their personal notes. Is that the issue?
That is correct, Mr. President.
Is that, okay.
That's how we understand it.
All right. The tribunal will take this up and be back to you. We don't have to decide this one today, I don't think. All right. Any other matters that we need to tend to? Hearing none.
Well, I mean, there was the issue of Mr. Retorto would like the
Oh,
confirmation.
sorry. We need the clarification on the technical situation in Lima or wherever we're going to be.
Of course. Mr. President, the background to this is that we indicated last week to opposing counsel when we were conducting certain tests that there had been some technical issues, that we were solving them. We did this, of course, in the interest of efficiency and transparency. The next day, those issues were resolved. We also indicated that to opposing counsel. At the moment, we do not anticipate any connectivity issues with Mr. Retuerto. And I take the opportunity to invite opposing counsel to raise these issues with us. I don't think that we need to take up the time of the tribunal. I think the coordination so far has been quite cooperative, and I expect that it will stay that way. If any issues arise, we will, of course, let you know as soon as possible. Thank you.
All right. Well, I welcome that spirit as we move forward. Remind me, when will we be doing the remote that comes up? Thursday, Friday?
It's Wednesday, sir.
Wednesday, okay.
It's Wednesday, and sir, if I may,
Please.
we are planning, and this is a formal invitation to both parties. We're planning to conduct a test, and we invite that test on tomorrow at the end of the day. So for counsel to have whoever is managing the connection on the remote side for the witness, we would plan on doing it after the hearing concludes tomorrow. And for counsel for claimant, if somebody wants to stay at the end of the day and see the conduct of that test, we will welcome you to.
Okay, well, thank you for that. Invite the parties to work with the secretary to attend to the arrangements that are required. Anything further on an administrative side? Okay, if not, let us turn to the claimant's opening. You have 3 hours available. At this point, do you assess, will you be using the full time allocated? If so, that's fine, but just for our planning purposes?
Yes.
Okay, very good. Then we are standing by.
Good morning. My name's Timothy Foden, and I'll be starting today's presentation. Now, I'm sure that the experienced members of this tribunal have sat on commercial arbitration cases before. So I'd like the members of the tribunal to imagine for a moment that you're hearing a commercial case regarding a breach of contract. And in this imaginary case, the respondent turns up to the hearing with the primary defense that it didn't breach the contract because it was unable to fulfill the relevant obligation in the first place. Now, you'd be sitting here thinking, how did a case where the respondent has effectively admitted to a breach even make it to hearing? Shouldn't this case have been settled ages ago? Well, you don't have to imagine it, because that is the case before you today, except it's an investment treaty case. Peru signed a free trade agreement just a few years ago, in 2009, that required it not to expropriate foreign investments and to provide those investments with full protection and security. Today, you're going to hear from our friends opposite that Peru's breaches are somehow excused for a variety of reasons, but predominantly owing to nebulous concepts of social license and its own inability to stem a growing tide of local unrest in relation to mining projects. But that's not how treaty obligations work. In fact, this is precisely what these obligations are there for in the first place. Think of how hollow and meaningless treaty standards would be if states simply shrugged their shoulders and said, in effect, we're unable to provide the protections for a treaty that we freely negotiated 14 years ago. We just can't do it. Like I said, if the respondent here was a commercial party, the award would write itself. But even Peru's attempts to clothe the inaction that resulted in its breaches of the FTA with some fashionable sense of ESG and social license simply don't marry with reality. The local community of Peron, of which you will hear so much this week, didn't blockade the claimant's mine because it had legitimate grievances or environmental concerns. Rather, this is a municipality with a long track record of criminality, which took my client's mine at gunpoint to both mine and sell its valuable ore and to protect its thriving marijuana business from police scrutiny. And in so doing, people were injured and a life was lost. That's worth repeating. In the course of their illegal takeover of the mine, Peron killed a subcontractor of Lupaka, gangland style, in a restaurant. So don't be fooled when Peru tells you this afternoon that it was some innocent rural community abused by a multinational mining company. On the contrary, Peron's conduct towards Lupaka could be described as both extortionate and, sadly, murderous. And what's more, Peron didn't actually have any legitimate claim to the area in which the claimant had actually built its mine infrastructure. And it's for that reason that the claimant was under no legal obligation to come to an agreement with the Peron community for land surface rights. But try it did anyway. The claimant made scores of good faith efforts to ensure a broad social license with Peron. Truly, Lupaka wanted to be a good neighbor. To that end, the claimant attended an endless series of meetings, even after it became clear that Peron had no real intention of negotiating and systematically reneged on each and every commitment it made to the claimants in the presence of government officials. Now, I hope you'll indulge me in one of a couple of analogies this morning. See, I have twin 8-year-old boys. One is bookish and small, and the other is aggressive and big. Obviously, they're fraternal. Over the years, when the bigger one picks on the little one, as he inevitably does, he'd never do it in my presence, and he'd always promise that he would stop. But as soon as I would leave the room, I'd hear the little one yelling, "Ouch!" In this case, Peron is the bigger boy, and Lupaka was the smaller one. The difference between me and the Central Peruvian authorities in this analogy is that after a while, I stopped believing that the bigger boy would honor his commitments, and I took action. I put him in timeout. Peru never took any action, either because it didn't care or it was incapable, Peru never took any steps to contain Perón's bullying. All they ever did was keep telling the claimant that they had to keep engaging in dialogue. Of course, that didn't work. Peru has a monopoly on police power within its borders. So sooner or later, it had to deploy its coercive power and put Perón in timeout. What Peru will tell you is that it couldn't justify the use of force in the circumstances. Not only because it would have been inconsistent with Peruvian law and policy, but because historically, and even now, in the midst of what is effectively a national emergency in Peru, its use of force has only exacerbated conflict. But how Peru uses its coercive power isn't for the claimant or even the tribunal to decide. It's not the investor's concern that the clear and obvious need for force is one that the sovereign state can't meet effectively because it has a history of using that force excessively. Of course, the claimant never wanted Peru to use excessive force. It simply wanted the central government to exercise its police powers in a responsible manner. And Peru was obligated under the treaty to do so. It can't excuse that obligation now by simply saying, sorry, we're really bad at it. To deploy another analogy, when the Los Angeles Police Department, they didn't stop policing in the wake of the unfortunate Rodney King episode 30 years ago, in which several police officers beat Mr. King savagely in public view in a grim reflection of that department's long history of brutality. Following that episode, when Los Angelinos called 911, they weren't met with a response, sorry, we won't come out to investigate your home invasion because we might use excessive force on the intruder. They did their jobs. Yet that's what Peru is telling you. They didn't come to my client's aid because historically they were really bad at doing so. That's simply not good enough. And the tribunal should dismiss it for what it is. It's the kind of balderdash that respondent states have come up with when they've clearly breached their obligations and they just have nothing else to say about it. Lupaka and any foreign investor has to be able to trust that Peru is going to exercise its police powers in an effective, responsive, and proportionate manner. The FTA's protections, they're not conditional in this regard. They provide protections, and the investor is allowed to expect that those protections will be deployed in a responsible manner. But in a sense, how Peru would have acted is immaterial because they didn't act at all. And who has benefited from Peru's intransigence? Well, since 2019, the Huara province of the Lima region has a new mining company. It's Perón itself. See, for 3 years now, Perón has mined the Invicta project. Now, remarkably, in yet another manifestation of Peru's ceaseless victim blaming, it argues that the claimant effectively got what it had coming to it. Specifically, Peru contends that Lupaka mismanaged its relationship with Perón by disregarding the community's environmental concerns. According to Peru, this prompted Perón's opposition to the project and its subsequent taking of the mine. Now, this is simply untrue. And the pictures that you're going to see on the screen in a moment, hopefully, make that falsehood abundantly clear. If Perón had environmental concerns, it would have made those concerns clear during the protracted discussions that it had with the claimant. It didn't. At no point did Perón flag concerns about environmental degradation. No, its concerns were far more base and selfish than that. And if Perón actually did harbor such environmental concerns, it certainly wouldn't be mining the mine itself, using extraction methods that are plainly environmentally hazardous. But that is apparently the case, as can be seen on the photos in the slide in front of you. So while Perón never flagged those concerns, it did raise its flag over the project, as you can see there on the slide. Now, maybe this afternoon, Peru will tell you that Perón isn't exploiting the mine, some 3 years after it first began doing so. 4 years, in fact. But I seriously doubt it. And that's because they can't. They can't issue such a denial. See, just last year, Peru opposed Peru's attempts to close the mine on 3 separate occasions. Do these seem like the actions of an aggrieved local community? No. This opposition just reflects only Peru's desire to keep exploiting the mine that it took at gunpoint from my client. None of this is in dispute. In fact, Peru didn't even address this illegal exploitation at all in its counter memorial. It only did so in its rejoinder. Think about that for a moment. The claimant's entire case theory here is that Peru took the Invicta project to mine it for itself, and Peru did nothing to stop them. Yet Peru didn't think it was necessary to address that case theory until some 18 months into this dispute. And when it did, Peru contended that we, as the claimant, haven't established that Peru planned all along to mine Invicta. Pardon me, but that is entirely besides the point. The claimant doesn't have to establish some mens rea component to prove a treaty breach, and the evidence speaks for itself. Peru is mining the Invicta project. You'll hear that this week from some of the witnesses. Now, this tribunal has to decide what it wants to do about that. Does it want to ignore or excuse the brazen theft of my client's project because Peru's lawyers have sought to mask a clear treaty breach behind some factually hollow social license defense? Or does it want to give meaning to the FTA and fulfill its mandate by compensating the claimant for the loss of its investment? I think it's pretty clear where we stand on that. Now, it remains for me to do 2 final things. First is to explain to the tribunal that when we speak of the claimant or my client or IMC or Lupaka, we're using those expressions interchangeably, though Mr. Velarde will explain to you the corporate structure of the claimant to make it clear. And second, I'd like to set out for you the order of our proceedings over the next 2.5 hours and change. First, you're going to hear from my friend, Luis Miguel Velarde, on the status of the Invicta project at the time of Peru's takeover and Lupaka's good faith efforts to reach an agreement with Peru. Then you're going to hear from Mr. Jaime Gallego on Peru's failure to protect Lupaka's investment in the resulting breaches of the FTA. Then you're going to hear from me again on the mine's mineral resources and the claimant's ability to meet its repayment obligations under the loan agreement that it had placed with a company called Pandion. And finally, you're going to hear from my old friend, Dr. Mark Veit, who's going to explain to you the compensation to which the claimant is entitled as a result of Peru's breaches of the FTA. So with that, I will hand it over to Mr. Velarde.
Good morning, Mr. President, members of the tribunal. My colleague Jaime Gallego and I will now address the factual part of our opening presentation. As we delve into the facts, please bear in mind that the main facts of this case are not in dispute. Where the parties disagree is on the implication of these facts. As Mr. Foden just said, I will first describe the Invicta mine and its status when the Paran community decided to take the mine, and I will then describe Lupaka's efforts to engage and reach an agreement with Paran, such efforts having failed because Paran did not want an agreement with Lupaka. I will then start with the first part. In October 2012, Lupaka acquired 100% of the shares of Andean American Gold Corp, and as a result, Invicta Mining Corp, or IMC, owner of the Invicta mining project and various mining concessions. At the time of Lupaka's acquisition in 2012, Andean had planned to develop a very ambitious mining project on the Victoria Uno concession. Essentially, Andean's mine plan assumed open pit ore extraction to process 5,100 tons per day of ore by means of an on-site processing plant. In 2014, 2 years after acquiring the Invicta project, Lupaka conducted mining and metallurgical studies with a view to revising the project's mine plan. Based on these studies, Lupaka decided to substantially modify the Invicta mine plan. In particular, it decided that mining at Invicta would be conducted entirely underground. The production rate would be significantly lower than forecasted by Andean, and that ore processing would be done fully off-site. These changes entailed a significant reduction in the social and environmental footprint of the project. Peru's Ministry of Energy and Mines approved the revised mine plan on 11 December 2014. The revised project remained focused on the Victoria I concession. The map you have on the screen shows the territorial boundaries of the Laxanga community, shaded in green in the upper half of the map, the Santo Domingo community, shaded in blue in the bottom right and in the center, and the Paran community, shaded in yellow. These are the official boundaries of the rural communities, which have been plotted using the coordinates from Peru's public registry, known as the SUNARP. The box in dark red is the surface on which the Laxanga community authorized IMC to conduct its mining activities, to build the mine infrastructure, and to use an access road to the project. The small elements in red represent Lupaka's mine infrastructure, some of which is also located on land belonging to Santo Domingo, with whom Lupaka also had an agreement signed in October 2010. As you can see, there was no mining activity or infrastructure on Paran's land. The claimant submitted this map with its memorial, and Peru did not challenge it in its counter-memorial. Peru's contemporaneous documents confirm that the project was located on land belonging to Laxanga and Santo Domingo. This was clearly stated in the operational plan prepared by the Sayan police in February 2019, the police force with jurisdiction over the area of the project. As you can see on the top of the screen, this plan acknowledges that 70% of the project is in Laxanga and 30% in Santo Domingo. Let me open a parenthesis here. The respondent has argued for the first time in its rejoinder that 3 of the mining components of the project were located on Paran's land, namely a water reservoir, a water well, and a pump house. The claimant has not had the chance to respond to this belated argument, which is opportunistic. Indeed, Peruvian authorities never told Lupaka that some of the project's mining components were located on Paran's land, and therefore that Lupaka needed to reach an agreement with this community to develop the project. Never. Instead, Peruvian authorities repeatedly requested Paran to lift the blockade, as is clear from the witness statements of Mr. Trigoso and Mr. Leon provided by Peru. This was because they knew that IMC had the necessary surface rights to develop the project. Peru's claim is not even supported by its own regulatory expert, Ms. Dufour. As you can see on the bottom of the slide, Ms. Dufour concedes in paragraph 330 of her report that, open quote, it is not an objective of this report to determine who is the owner of the land where the Invicta project components are located. Peru's belated allegation is also incorrect. One of the mining components Peru refers to is a water well located in Huamboy, specifically on land belonging to Mr. Marcos Tena, a former IMC employee. As stated in an administrative resolution issued by Peru's Water Authority in 2009, this well is drilled on property belonging to Mr. Marco Tena, who by means of an agreement has ceded his land for the construction and operation of this well to IMC. As to the other two mining components, Peru's claim ignores that they were not necessary to develop the project. Mr. Julio Castañeda, IMC's former general manager, will be here with us this week to explain this issue further. With this, I close the parentheses regarding these three mining components.
Council, can I interrupt you for a second? The map on page 14 that we have in our print doesn't include the boxed in part of the Lasagna lands which came up on our screen. We don't have that box part on our print.
Thank you. We can update the map. It is on the record with the box. It's just a printing issue.
Well, perhaps it could be scrawled in on our prints that you handed up. Not now, of course.
Okay.
Yeah, perhaps most efficiently, you can just provide us a corrected print of this map with the missing data shown.
Yeah, happy to do so. Thank you. Where was I? Next slide. As I noted before, the authorities approved IMC's revised mine plan in December 2014. From that point onwards, Lupaka invested time and resources to develop the project. The claimant addressed these developments in section 3.1 of its reply, and Peru has not denied them. Let me mention three milestones. First, Lupaka had the key permits and approvals to develop the project, including an environmental impact assessment study and a mine closure plan, both updated in 2015 and 2016 as required by Peruvian law. These are the key environmental instruments of any mining project. You can see other permits and approvals listed on the screen. Second, as I mentioned before, Lupaka had the necessary surface rights from the communities of Laxanga and Santo Domingo to develop the project. The surface rights agreements with Laxanga had led to Lupaka building an access road to the project site. You can see on the screen an official map taken from the website of the Ministry of Agriculture of Peru, which the claimant submitted with its memorial. This official map shows the borders between the three rural communities, which, to be clear, are part of the original map. The claimant did not add them. The claimant only added the boxes with the names of the communities corresponding to each territory. In this official map, one can see the Laxanga access road to the site and that it does not enter Paran's land. Third, Lupaka had funding to develop the project. In June 2016, Lupaka signed a financing agreement with PLI Waura, providing Lupaka with $7 million to develop the project. Lupaka used these funds in its mine preparation and development works, which were completed before the blockade. So Lupaka had the land, Lupaka had the permits, and Lupaka had the funding to develop the project by October 2018, when Paran blocked the Laxanga access road to the site. There were only two outstanding issues before Lupaka could exploit the mine at the time of the invasion by Paran, which I will address in a moment. Peru agreed on these two issues as being the only ones that were pending in its counter-memorial. It also referred to the amendment of the project's mine closure plan, but then it agreed it was not necessary. In its rejoinder, however, the state added new requirements in its rejoinder. I will also address them. The first pending issue was the final inspection of the mine by the Ministry of Energy. As you can see on the screen, on 6 September 2018, that is 1 month before the blockade, Lupaka informed the ministry that it had concluded its mine preparation and development works and requested that the final inspection be conducted. This inspection could not take place due to the blockade. Had this inspection been conducted, Lupaka would have passed it. The second pending issue was the certification of Lupaka's water management system. Lupaka built this system in mid-2018 in response to the findings from Peru's Environmental Enforcement Agency, the OEFA, that some of the Invicta mine effluents exceeded the maximum permissible limits. The purpose of Lupaka's water system was twofold. First, to ensure that the mine effluents complied with the maximum permissible limits, and second, to ensure that all mine effluents were reused in IMC's Invicta's activities. To achieve this, Lupaka's water system consisted of 2 ponds excavated in the rock and located inside the mine tunnels next to each other. The effluents from the mine entered the first point, which you can see on the right, where it was purified and then transferred through 3 pipelines to the second pond, from where it was then pumped to the upper levels of the mine to be reused in IMC's mining activities. Lupaka's water system proved to be effective before the blockade. The first document you have on the screen is a directorial resolution issued by Peru's Environmental Enforcement Agency, the OEFA. This resolution refers to laboratory tests conducted on 20 June 2018, that is some 4 months before the blockade, which confirmed that the Invicta mine effluents, open quote, have values within the maximum permissible limits. Peru has never contested these findings. The next document on the screen is a technical report issued by the Water Authority in the area of the project, the Waura Water Authority, in July 2018, some 3 months before the blockade. In paragraph 5.3 of this report, the Water Authority confirms, after conducting an inspection at the Invicta mine, that, open quote, there is no evidence of off-mine wastewater discharge. And then in paragraph 6.3 states, open quote, that no direct impact on the water resources of the community of Paran and surrounding areas has been found. In other words, as of July 2018, Lupaka's water system was up and running, and Peru's Water Authority had confirmed its effectiveness. Lupaka should have had no difficulties in certifying its water system in the second semester of 2018. Now, you will hear Peru take an extremely formalistic view here to delay the start date of exploitation at Invicta. Even though Lupaka built its water management system to comply with the maximum permissible limits as requested by the OEFA, and even though Peru's own water authority confirmed that Lupaka's water system prevented any impact on the water sources of the Paran community, Peru will tell you, further to the expert opinion of Ms. Dufour, that Peruvian law does not admit the possibility of building or operating first a mining component and certifying it later. Hence, Peru's case is that Lupaka needed to destroy its fully functional water system, obtain its environmental certification, and then rebuild that same system from scratch. This, of course, makes no sense. You will be hearing from Mr. Castañeda on this week.
Counsel, let me just interrupt you briefly. Is there any evidence on that point other than the report, the expert report?
On that point, you mean which point?
The point that the system had to be destroyed so that it could be rebuilt.
No, this is only addressed in Ms. Dufour's expert report submitted with the rejoinder and nowhere else. These were the only pending requirements addressed in Peru's counter-memorial. However, as mentioned, Peru changed its position in the rejoinder. As you can see on the bottom of the screen, further to Mrs. Dufour's expert report, Peru argued for the first time in its rejoinder, that Lupaka also needed to obtain additional water licenses and other permits, and also to obtain registration on the hydrocarbons registry before it could start exploiting at Invicta. These new requirements were not raised contemporaneously, and the claimant, of course, has had no chance to address them. They should therefore be disregarded. And just as the claimant has had no chance to address these new requirements, it has also not been able to address the unreasonably long time that Peru's regulatory expert assumes it would have taken Lupaka to comply with these requirements. As you can see on the screen, Peru's regulatory expert assumes that Lupaka would have taken much longer than the maximum legal timeframes to obtain these new permits and approvals, sometimes 4 times as much, based on what the expert calls the actual timeframes. This is unreasonable for at least 2 reasons. First, because Peru's case is premised on conduct of its public officials being in breach of the mandatory deadlines provided in Peru's own law. The respondent cannot rely on its own turpitude. Second, Peru's expert only relies on a very small sample of cases to support the actual timeframes she uses. Therefore, even if the tribunal were to conclude that Lupaka needed to comply with these new requirements, quod non, the tribunal should use the legal timeframes and dismiss Ms. Dufour's so-called actual timeframes. It should be noted in any event that even under all these unreasonable assumptions, Peru's regulatory expert concludes that Lupaka could have started processing Invicta's ore with the Malay plant in January 2020. This is the very same date on which Mr. Gordon Ellis, Lupaka's founder and president, has testified that Lupaka would have had to start making gold repayments to PLI Waura further to the acquisition of the Malay plant. My colleagues will refer to this acquisition later. However, the point now is that the analysis of Peru's regulatory expert is moot, as she concedes that the permits would have been granted by the time the processing was due to start. I will now move on to the second part of my presentation, where I will describe the many actions that Lupaka undertook to engage with Paran and why an agreement was not reached. Let me start with a preliminary comment. As I showed earlier, the project was located on land belonging to Laxanga and Santo Domingo, not on Paran's land. This is important because Peruvian law only required Lupaka to reach an agreement with the owners of the land where the project was located, which Lupaka did. You have on the screen Article 23 of Peru's mining regulations. This article establishes the requirements that Lupaka needed to comply with before it could start exploiting the Invicta mine. The requirement in A was complied with when the National Institute of Culture issued certificates of absence of archaeological ruins in 2009 and 2010. This is Exhibit C59. The requirement in B is to have the environmental certification issued by the competent authority, subject to the rules of citizen participation. The project also complied with this. Its environmental impact assessment study was approved by the Ministry of Energy in 2009, after IMC conducted the citizen participation activities mandated by law in the area of influence of the project, and was then modified in 2015 and 2016 and approved by the authorities. Peru disputes that the social obligations contained therein were complied with. I will address this in a moment. The requirement in C is to obtain permission for the use of land by prior agreement with the owner of the terrain. Lupaka complied with this by signing surface rights agreements with Laxanga and Santo Domingo. And the requirement in D is to obtain any other licenses, permits, and authorizations required by the legislation. These are the specific pending requirements that I discussed before and which relate to Ms. Dufour's opinion. As you can see, nowhere in Article 23 is there a requirement for Lupaka to reach an agreement with Paran to develop the project. While Peru's position on this issue is nebulous, it appears to concede that there is no express legal obligation in this regard. However, Peru and its witnesses try to fill this void by resorting to the notion of social license to operate. Peru's witness, Mr. Trigoso, states that, open quote, beyond the legal obligation, experience shows that for a mining project to be successful, the mining company must obtain and maintain the approval and support of the communities in the area, including the Paran community. The claimant is of course aware of the notion of social license to operate. But this notion cannot be discussed in the abstract. Peruvian mining law is sophisticated and regulates what a mining company must do to obtain a social license to operate from the surrounding communities. This is reflected in the specific social obligations that mining operators must comply with in relation to mining projects. One of these social obligations is to conduct citizen participation activities with the rural communities in the area of influence of the mining project, which is mentioned in the Article 23 point B of Peru's mining regulations that we just saw, and which Lupaka complied with. The claimant addressed the citizen participation activities conducted by IMC in section 3.2.1 of its reply. Another social obligation under Peruvian law is to prepare and execute the social programs provided in a mining project's environmental impact assessment study. Lupaka again complied with this, which is not a minimum as Peru contends. This is an obligation that Peruvian law imposes on mining companies. On these social obligations, Peru will tell you that Lupaka did not comply with all of them because in 2016 and 2017, the UEFA found that Lupaka had not implemented some education and health-related programs, among others. But this criticism is unwarranted because, as we explained in section 4.3.3 of the reply, during this period, Lupaka's activities at the project were suspended, as the company was in critical negotiations with Laxanga and Paran to secure an access road to the project. The state was informed about this. Without an access road, the project could simply not be developed. There would be no project. Lupaka secured the right to build this access road and started executing these social commitments, including the Paran community in all social activities planned for 2018. Peru and its witnesses adopt a notion of social license to operate that goes beyond Peruvian law and that assumes that a mining company is obliged to reach an agreement with a local community at any price, even if the community is clearly acting in bad faith. This is not reasonable. Peru will also tell you that Lupaka's view that it was not obliged to reach an agreement with Paran confirms its disregard for this community. This is false. Lupaka strived to engage with Paran as it knew it was important to have a good understanding with surrounding communities. Lupaka also wanted to secure an alternative route to the project through Paran. Let me refer to some of the efforts that Lupaka made in this regard. Lupaka started engaging with Paran shortly after it acquired the project in October 2012. For example, from 2013 to 2015, as you can see on the upper part of the screen, Lupaka supported infrastructure projects for the benefit of Paran. In the next excerpt on the slide, you can see that Lupaka engaged with a large number of individual members of the Paran community, visiting their farmland and providing technical assistance on agricultural practices. Lupaka knew this would be of interest as Paran is an agricultural community. The next excerpt on the bottom of the screen is taken from the witness statement of Mr. Eric Edwards, CEO and President of Lupaka between 2011 and 2015, and witness for the claimant in this case. In paragraph 64C, Mr. Edwards also refers to IMC, open quote, one-to-one interactions with individual community members, but also discusses, you can see this in paragraph B, IMC's engagement with the rural communities as a whole, referring to the frequent meetings held by IMC's community relations team with the rural communities to discuss the project. Mr. Edwards also refers to Lupaka's opening of a local office to allow members of the rural communities, including of course Paran, to stop by, ask questions about the project, and share concerns. You have this in paragraph 64A of Mr. Edwards' witness statement. Confidential information. Importantly, Peru's authorities never complained about Lupaka's engagement efforts. Never. Peru will tell you that this was the case because the state entity on the ground in charge of fostering dialogue does not have a preventive role. This runs contrary to common sense and is obviously an excuse made up for the arbitration. Building on these engagement efforts, Lupaka and Paran entered into discussions in 2016 with a view to concluding an agreement. On 6 October 2016, Lupaka sent Paran a detailed proposal for an agreement which included an investment of $200,000 per year, or $2 million over a 10-year period, in projects related to water infrastructure, the development of agricultural techniques, and others to be defined by Paran. I will not go into the details of this proposal, which you can see on the screen, and which Mr. Julio Castañeda addresses in section 5.4 of his first witness statement. In exchange for Lupaka's commitments, Paran would commit to allow Lupaka to use an access road to the site through Paran, among other things. Peru has not criticized Lupaka's good faith proposal in any way. Paran made a counter-proposal to Lupaka in November 2016. Again, I will not go into the details of this counter-proposal in the interest of time, which Mr. Julio Castañeda also addresses in section 5.4 of his first witness statement. I will just say that Lupaka made an effort to accommodate a large part of Paran's counter-proposals, including, as you can see on the left side of the screen, by increasing the amount of the yearly investments and by accepting to contract all companies in Paran to provide services to the project. You have this on the lower part of the screen. Confidential information. Lupaka was making every effort to reach an agreement with Paran, so it accepted to pay the 300,000 soles before an agreement was signed, just as Paran requested. Lupaka paid this in 2 installments, the first on 18 December 2017 and the second on 31st January 2018. Note that Lupaka paid this debt and continued negotiations with Paran when Lupaka had already secured an access road to the project site through Laxanga. The agreement with Laxanga was signed in July 2017. If Lupaka's only interest was to secure an access road to the site, as Peru will tell you, Lupaka would not have paid Paran because it had already secured such an access road. Lupaka paid because it wanted to reach an agreement with the Paran community. Bear this in mind when Peru tells you that Lupaka disregarded or marginalized Paran. This is simply false.
Council, let me interrupt you. I think it would be timely at this point if we could take a 5-minute break on the scheduled break time. Would that be convenient for you? Is this a suitable time? We need to do this fairly quickly, though.
This is fine. I have 2 more pages to go, but this is fine.
Let's just rise for just 5 minutes.
Okay.
while we wait for the tribunal to reconstitute itself, we've managed to stretch this 5-minute break now to 8 minutes, so we need to make sure that we keep these within reasonable time. So I would discourage you from leaving the room during these unless you need to, because I want to minimize the amount of time that we use for these purposes. All right, are we ready to resume? All right, Counsel, over to you.
Thank you, Mr. President. Before the break, I told you that Lupaka paid the 300,000 soles, some $88,000, requested by the Paran community. Lupaka expected to resume dialogue regarding an agreement with Paran shortly after paying these 300,000 soles. As you can see in the first excerpt on the screen, which is a monthly report prepared by IMC's Community Relations team, Paran told Lupaka that dialogue with the company would begin once the company had paid the 300,000 soles. And the second excerpt shows that the Paran leadership confirmed this when it received this payment. Lupaka expected to rapidly reach an agreement because, as we saw, 90% of Paran's members agreed with Lupaka's revised proposal. Yet, Paran disregarded its commitment and imposed new conditions before resuming negotiations. Specifically, Paran refused to resume negotiations, first until Lupaka paid a penalty that Paran had unilaterally imposed in relation to the same 300,000 soles debt. While contemporaneous documents show there was some back and forth in relation to this penalty, Paran finally agreed to set it aside. On screen, you have the letter that IMC sent to Paran summarizing the agreements reached after a meeting with the president of Paran, its governing committee, and legal advisors, which leaves no doubt about this. And second, Paran also required compensation for exploration works carried out on Paran's land. Note that the letter sent to Lupaka requesting this compensation is dated 19 December 2017, but was only delivered to Lupaka 2 months later, when Lupaka had already paid Paran the full 300,000 soles. Lupaka could not accept these new payment requests. Paran was asking that Lupaka continue making significant payments in the hope of resuming negotiations at some point, something that Lupaka was no longer sure would happen. If anything, Paran's behavior showed that it was trying to extract money out of the company without a real interest in reaching an agreement. This was in the first quarter of 2018, and things only got worse thereafter. Paran started taking active measures against the project. Let me give you 2 examples which are not in dispute. First, on the left of the screen, you have an excerpt of a report prepared by IMC's Community Relations team in March 2018. There, you can see that Paran proposed to Santo Domingo to form an alliance against the project, offering in exchange to give up on its territorial dispute with Santo Domingo. You will hear Peru refer to territorial disputes between Paran and the other communities, and how that supposedly obliged Lupaka to reach an agreement with Paran. Well, here, as you can see, Paran was offering to give up on its land claims if Santo Domingo agreed to block the project. Second example, in May 2018, the president of Paran tried to convince the president of Santo Domingo to demand 4 million soles more from Lupaka. This is some $1.3 million for the use of the Santo Domingo land, proposing to split that money in equal parts. But Paran wasn't just taking actions against Lupaka. It was also taking actions against the other communities. In the interest of time, I will just say that Paran insisted over time on its request that Lupaka transport all its ore exclusively through Paran. Lupaka informed the state that this request blocked any possibility of an agreement because first it was unfair to the other communities, and also ignored that Lupaka was obliged to make significant annual payments to Laxanga for the use of its road. Members of the tribunal, I have just described the reasons why Lupaka could not reach an agreement with Paran. It was not because Lupaka had an inexperienced community relations team, as Peru wants you to believe. No. Paran did not want an agreement with Lupaka. Why it did not wish to do so is not material. However, the state's own internal documents show that this was because the Paran community believed the project would interfere with the drug business on Paran's territory. Peru says this doesn't make sense, yet its own civil servants were stating this at the time. Peru cannot criticize the terms of the proposals that Lupaka made to Paran to reach an agreement because, as we saw, 90% of Paran accepted Lupaka's proposal. Instead, Peru tries to confuse matters by saying that Lupaka gave preference to Laxanga. But let us recall that to get the project off the ground, Lupaka needed to have an agreement with Laxanga, in whose territory the project was located. But even after Lupaka reached an agreement with Laxanga, Lupaka continued making efforts to reach an agreement with Paran to no avail. Before giving the floor to Mr. Gallego, I just realized that in the transcript, when I was discussing about the water management system, which consists of two ponds, I think that the transcript shows points instead of ponds. So just to clarify that. With this, I give the floor to Mr. Gallego to address the last part of our factual presentation. Thank you.
Council, could I ask you what the word bocamina means? I'm sorry, I'm not a Spanish speaker. Bocamina in the box on page 40, what's that?
That's the mine added, if I'm not
It's added.
It's the entrance to,
It's the
to the
entrance.
mine.
Thank you.
Members of the tribunal, I will be taking about 45 minutes for the remainder of, for this part of the presentation.
Right, we are scheduled, I think, for an official break at 10 minutes after the hour, quarter after the hour. Perhaps as you draw near to that, you'll let us know an appropriate point for us to take that break.
Thank you, Mr. Chairman. I'll now address the state's failure to restore law and order despite Paran's illegal actions. As Mr. Velarde just explained, Paran was not negotiating in good faith, and its menacing discourse only grew worse despite Lupaka's efforts. On 4 May 2018, Paran sent a letter to IMC falsely claiming that IMC has taken possession of our land, installing a camp, and contaminating our springs. Based on these false accusations, Paran gave Lupaka an ultimatum. As can be seen from the letter, Paran stated, "We ask you to vacate the territory of our rural community within 15 calendar days. Otherwise, we will proceed to evict you." This was the prelude to the violent invasion of June 2018. IMC's community relations team met with Paran leadership on 15 June 2018 in an attempt to avoid the invasion by Peran. This was to no avail. During this meeting, Peran's leadership informed IMC that Mr. Soyman Retuerto, then sub-prefect of the Leoncio Prado district and one of Peru's witnesses in this arbitration, had authorized Peran to invade the mine. This was memorialized in the report for the month of June 2018, prepared by IMC's Community Relations team. Confidential information. 3 July 2018, Peran wrote to the Minister of Energy and Mines to give its version of these events. And this is what Peran said. Recently, in an ordinary assembly, we decided to carry out a peaceful inspection inside the facilities of the mining company with the intention of verifying for ourselves what they have been denying, that they are working. The case being that we found that they are indeed working. And then the letter goes on to say that there are environmental violations. This is just another example of Peran's false accusations. Not only had the armed invasion been brutally violent, but IMC was not exploiting the mine, nor were there contamination in the way they alleged. None of this is in dispute. Peran planned a new invasion of the site for 11 September 2018. However, on 10 September 2018, the police did intervene in view of Peran's announced invasion for the next day. The order for the police intervention is at C136 and projected on the screen. The first highlighted portion of the extract shows that police had a wide mandate to ensure that public order was maintained. The second highlighted portion further shows that the role of the police was and is to guarantee compliance with the law and re-establish public order. Doing so was not discretionary for the police, as is Peru's case. It is required to do so, and it was going to counter the use of force or violence by Peran with appropriate means. On 10 October 2018, Peran sent a letter to the Minister of Energy and Mines, again making a new series of false accusations against Invicta about the exploitation of the mine and the supposed environmental breaches. This letter was a clear attempt by Peran to justify the invasion that would take place only 4 days later, and is another example of Peran's bad faith. Confidential. Yet Peru states that its response to this invasion was, and I quote, reasonable. It also blames Lupaka for not seeking help early enough, which of course makes no sense. Peru states that because of the October invasion, Peran was already on the ground and armed. The police's decision not to intervene was, and I quote, entirely consistent with Peruvian law. This is obviously mistaken. Peruvian law is clear that there should be police intervention in the circumstances. First, the Constitution's basic tenet on law enforcement, found in Article 166 of the Constitution, says the fundamental purpose of the national police is to guarantee, maintain, and re-establish internal order. It provides the protection and assistance of the persons and the community. It ensures compliance with the law and the security of public and private property. It prevents, investigates, and combats crime. Even under this basic tenet, it is clear that the state should have intervened to redress Peran's criminal conduct, and thereby allow IMC to continue with its mining project at Invicta. Second, there is Article 920 of the Civil Code. 3 days after the invasion, on 17 October 2018, Invicta sent a letter to the police requesting police support to recover possession of the site. The police was obliged to assist Invicta in recovering control of the site. Indeed, Article 920 of the Peruvian Civil Code, which regulates the so-called extrajudicial possession defense, leaves no room for any doubt in this regard. As can be seen from the last extract at the bottom of the slide, the National Police of Peru must provide the necessary support to guarantee strict compliance with this article, under penalty of the law. Peru has said on this that Article 920 only requires that the police play a supporting and supervisory role with respect to a dispossessed property owner's own efforts to regain their property. It also states that the police's assistance or support could not have taken the form of use of force as a result of this article. This is worth a brief comment. As the tribunal is well aware, the situation is that Paran had invaded the site and set up a roadblock with 100 of its members who were heavily armed and had proven to be very violent. Peru seems to be suggesting that Lupaka had the right to organize a security force in the circumstances to evict the Paran invaders, and that if it had done so, Peru's police would have stood by and watched. It is ironic that Peru is suggesting this when it criticizes the intervention of WDS, Lupaka's private security force, a few months later. Peru's position is also contrary to the reality in Peru. In the case of Las Bambas, which is a major copper mine in Peru, whose operations have also been blocked by communities, the police did carry out a forceful intervention in 2022 precisely on the basis of this Article 920 of the Civil Code, as one can see from a report of the Ombudsman that is on file and that is on the screen. Peru also says that Lupaka did not comply with the requirements of Article 920, and that's at rejoinder paragraph 185, and tries to create confusion by referring to regulations that apply to the recovery of state-owned land. Yet a simple reading of this provision, that is 920, shows that Lupaka only had to inform the police about the dispossession and request support, which it did, as we have seen. No Peruvian authority ever told Lupaka that it would not receive police support because of protocol requirements. Third, Peru's own defense in this arbitration confirms that the police must intervene in the circumstances such as these. Peru's criminal law expert, Mr. Maney, explained, I open quote, "The use of force is never discretionary, and that the police can and should use force in any of the situations listed in Article 8.2 of Legislative Decree 1186. Here, we are at least in 2 of the situations, if not more, specified in Article 8.2. That is, namely, to detain a person committing a crime and to protect or defend protected legal interests. Indeed, Paran were on Laxanga's land continuously and were blocking IMC from accessing its own site and its right to exploit the mine. In the words of Peru's criminal expert, Mr. Maney, the police can and should use force in these circumstances. But the tribunal does not need to decide this matter under Peruvian law. It is making a decision under international law. It is clear that under international law, Peru had an obligation to protect foreign investors from criminals. Already at this point, there was at very least a breach of the obligation under international law to afford FPS to Lupaka's investment. Aware of its duty to intervene, the police initially responded positively. Indeed, on 25 October 2018, 8 days after Lupaka's letter, the police informed IMC that the PNP Colonel Chief of Huacho Police Division has ordered that the respective order of operations be formulated in order to be able to provide the police support and thus maintain public law and order. However, ultimately, the police did not intervene. As we will see as we go through the chronology, this was only one of several instances where the police made it clear that it believed that forceful intervention should take place in order to allow IMC to recover access to the mining site. Paran was armed at the time because Peru's army provided arms to it in the 1990s when it created the Rondas Campesinas. This is confirmed by Peru in this arbitration. You can also see this referenced in an internal PCM document at the top of the screen. That is, PCM is an organ of the Peruvian state. The police operational plan states that Peru's Rondas Campesinas had some 16 rifles provided by the army. On the slide, is an extract from the police operational plan confirming this. And Peru was also in possession of other arms, as the police operational plan also confirms, and which you can see on the second extract, confirming that other than the rifles, they held pistols, revolvers, and carabines. Peru was also in control of Invicta's explosives magazine, which contained various tons of explosives. This is also confirmed by the report attached to the police operational plan. In response, Peru states, I quote, "There is no evidence to suggest that during the Access Road protest or during the encounter with the WDS on 14 May 2019, the Peru's Ronda Campesina actually used any of the firearms that had been distributed to it decades earlier by the Peruvian military." However,
A quick question, Counsel. What is the Spanish word used for rifles here in the original?
I think it's retrocargas,
Retrocargas.
which is a little bit of an old-fashioned word in my opinion, but I would translate it as rifles.
But it says 12 gauge, 16 12 gauge rifles. I thought a 12 gauge refers to a shotgun. Anyway, it doesn't matter. But it is interesting that retrocargas.
Now,
Retrocargas could be a shotgun that is. Never mind.
As
Thank
one
you.
who wandered around the fields as a misspent boyhood carrying a 12 gauge, it is a shotgun.
thank you, Mr. President. I think that there is a discussion about long-range weapons and short-range weapons, and that's reflected in the evidence. In any event, whether they were given shotguns or rifles, the point stands. There were 16 of them provided to the Peruvian community by the army. So Peru says that there's no evidence that they actually had these weapons provided by the army during the Access Road protest or during the incident of 14 May 2019. Now, if you see the letter on the screen from 25 January 2019 from the Huacho Police Department to the head of the Lima region, General Arata, requesting that General Arata order that the arms provided by the army to Peru's Ronda Campesina be confiscated, as it is misusing them. Now, that is in the first highlighted portion. In its reasoning, it explains how a Laxanga inhabitant has received multiple wounds as a result, and that the Peruvian community has been carrying out the forceful blockade since October 2018. And that's in the second and third highlighted portions. Now, this is obviously contrary to Peru's position. Sadly, this plea from the police in January 2019 fell on deaf ears at the time. And Peru also ignores this letter in this arbitration, despite the claimant having referred to it in the reply. As to the events of 14 May 2019, it is undisputed that approximately 100 heavily armed members of Peru entered the site, opened fire against the WDS guards, and Mr. Estrada as well, and that is IMC's employee. Peru's members would have likely been carrying all the arms they had, including those provided by the state. Now, Peru's response is that, I quote, "Importantly, claimant has not shown that a forcible stripping of such weapons, had it taken place, would have dampened the community's opposition, prevented the road access protest, or in any way helped to resolve the conflict." And that's in paragraph 286 of the rejoinder. Now, this is wholly disingenuous and defies any logic. It is not the same to confront. It's not the same to confront a heavily armed mob than to confront one that is not. The police should have been able to lift the blockade in such wholly different circumstances, and WDS would have been able to hold its ground at the site in May 2019. Now, I'll come back to this event later. Now, I've just been informed that it's actually escopetas, which is rifles, in the original.
Sorry, escopeta is not rifle. Escopeta is shotgun.
Okay. By this point, it was entirely clear. I respectfully disagree with that, Mr. Garibaldi, and I'm sorry. We'll have a look at that. But anyway, I'll carry on for the sake of.
Counsel, if you want to
time.
attach the word 12 gauge, I think you're stuck with a shotgun unless you're very convincing.
Thank you, sir. Take note. By this point, it was entirely clear that Peru's police's forces should intervene. This with the view not only of Lupaka, but also of the police. Following Lupaka's further requests for police intervention in early December 2018, the police had been assessing an intervention. This has not been contested by Peru. On the slide is an internal police document showing the various approvals obtained relating to such intervention. The document shows approvals by the General Staff Office for operational plans in Lima, the legal department of the police in Lima, and the police division in Huacho. Now, this is why the police had finalized an operational plan dated 9 February 2019, which is at C193, and which CPO Soria sent to his superior in Huacho for approval and onward transmission to Lima. The operational plan is a very detailed account, of which 55 pages are on file, out of 105 pages, which CPO Soria sent to his superior on 9 February 2019, as can be seen from the slide. The plan provided for 280 police officers to be on the ground, 280, of which 200 would be from the Specials Operations Unit in Lima and the rest from other police units. It is clear that this plan had been prepared over a significant period of time and had been finalized. Indeed, the operational plan had been carefully prepared. It mapped out a phase strategy, as you can see from the points that have been put on the slide. The operational plan also had an intelligence report, as well as a report evaluating the risk attached to the same. And as Mr. Bravo testifies, the police authorities also took the time to meet with IMC and coordinate critical aspects of the operational plan. On 20 February 2019, Mr. Bravo coordinated further with Colonel Arbulu to suggest he approve the plan. Mr. Bravo received confirmation of this on 14 February 2019. Also on 14 February 2019, Mr. Bravo coordinated with CPO Soria to tie off any remaining points before the plan went ahead. And he received oral confirmation. Mr. Bravo received oral confirmation that all the police hierarchy had approved the plan. Mr. Bravo then received confirmation that 19 February 2019 was set as the date for its execution. Despite all this, the plan did not go ahead. Now, Peru has not contested any of this evidence. However, Peru does make the general allegation that the police acts autonomously, and that if the plan did not go ahead, it is because the police decided that they should not, and that they are entitled to do so under Peruvian law. Yet this story does not match Peru's internal documents, nor Mr. Bravo's understanding at the time. All the evidence points to the fact that it was Mr. Saavedra or other high-ranking officials within the Ministry of Interior who blocked the implementation of the operational plan. Now, for example, as can be seen on the slide, Mr. Saavedra candidly stated in a WhatsApp message to Mr. Bravo on 15 February 2019 that the implementation of the operational plan could not go ahead because, he said, if we do not adhere to the protocol on the use of public force and there are consequences, these will fall back on the country and the national and international press will do their thing, which is why we must be scrupulous. The inference here is clearly that Mr. Saavedra feared negative political consequences. Mr. Saavedra comments on this very briefly in paragraph 23 of his statement. He says that it is untrue that unfavorable publicity in the media was the only consideration, yet he does not give any further explanations. Ultimately, the tribunal does not need to decide whether it was the Ministry of the Interior or another instance that blocked the police operational plan. What matters is that there was no good reason not to proceed, given the circumstances. Peran was acting criminally by taking Lupaka's mining site with violence. Its members were brandishing firearms. They were using them against Laksanga members, and they had taken control of IMC's explosive magazine. Peran had also been so bold as to impede an inspection of the explosives magazine by the prosecutor, accompanied by the police on 2 occasions, in December 2018 and February 2019, and had also shown repeatedly and without exception that they were not willing to enter into any reasonable dialogue to come to an agreement. It is for this reason that the police operational plan at C193 was a finalized document, which had been prepared and approved by numerous police instances. Its implementation made sense to many within the police forces, not least of which those officers on the ground and those not focusing on a political agenda.
Counsel, I see from your slides that we're about to move to the 26 February agreement. Perhaps this would be a time for us to take our break.
Yes, it would. Thank you, Mr. Chair.
Let me invite you, when you come back, could you briefly clarify for us the relevance, as a matter of international law, of all we have heard about who did or did not block the performance of the intervention plan? How is that relevant to your international law argument that there was a failure of full protection and security? Just very briefly. Thank you.
Council, could I also flag, perhaps not for your opening, but I note on page 60 of the slides, the last dot point in the first box is that the guarding of the site by the police for a maximum of 72 hours, perhaps at some time before final addresses. We're not having a final address, but sometimes might we have submissions on the relationship between a police intervention for 72 hours and the capacity to conduct the mining operations.
All right, let's convene in 10 minutes. Respondents ready? Appear to be. Reporters, are you ready? Okay, we're still missing some of claimant's team. Can we start, or do we need to wait? Okay.
Microphone.
Thank you. I'll just address the two questions in order. First, as to the relevance as to who blocked, it's a matter of international law. It is not for us to say who blocked the police operational plan. The evidence that we are marshalling shows that numerous individuals within the police and also outside the police in other state organs thought that the police should intervene. Now that is a clear demonstration that this should have happened if you needed it, given the circumstances of Peru's actions. As to the second question on 72 hours and the capacity to conduct the mining operations, it is Lupaka's submission that what should have happened here is that the Peran community should have been disarmed. Lupaka precisely was contracting WDS as a security force to enter with the police and to be able to secure its own site once the police had left after 72 hours. In any event, the police should have provided sufficient security to protect them against a further invasion by Peran. The claimant has provided evidence that the Ministry of Energy and Mining's team in charge of mediating negotiations with the community, the OGGS, knew that further negotiations were going to be unproductive by early 2019. The evidence here is again directly from Peru's internal documents, and where officials are stating in no uncertain terms that there is no point in continuing the negotiations. For example, let us see C468 of 20 February 2019, which was already shown by Mr. Velarde. The author, Mr. Leon, one of Peru's witnesses in this arbitration, states as follows: the social process that the mining company maintains with the community is affected by the presence of interests outside the state. Producers of local marijuana plantations. The Minister is aware of this problem and is activating the corresponding mechanisms. Also, it is known that the local police is preparing an operations plan in the community, having identified long-range weapons among community members. Recommendations. Coordination at the highest intersectoral level between the MEM and the Ministry of the Interior in order to activate as soon as possible the mechanisms for the re-establishment of public order in the area by the Minister. Dialogue mechanisms are not appropriate in the case because the community leadership manages a double discourse with the state and with its population, evidencing with it the presence and active participation of local actors who, with an economy outside the law, subsidize activities contrary to public order against the mining project. Now, what does Peru say to this? It says that these are just the opinions of a civil servant at a particular time, but not the institution's opinion. That is, the institution thought it reasonable for dialogue to proceed. Now, this is highly questionable on the face of this document, and others like it. In any event, even if Peru's position was correct, these documents are devastating for Peru's case because it shows that the opinion of several people from the OGGS who attended meetings on the ground with Peran was that further negotiations were not going to yield any results in light of the fact that Peran had among its ranks drug traffickers who would not see the benefit of an agreement with Lupaka. Following the decision by a higher authority in the state that the police should not intervene, there were negotiations with Peran on 26 February 2019. These led to a preliminary agreement with Peran with obligations for both Peran and Lupaka. But the agreement was only a first step. It merely started what in Peru is called a dialogue table, a formal setting in which the parties would further negotiate with the intermediation of the state to reach a fuller agreement. Now, Peru heavily relies on this 26 February 2019 agreement for two main points. First, it says it is proof that there could be agreements with Peran, and therefore that it was right not to order forcible intervention. Second, that the events subsequent to this, particularly concerning the topographer mentioned in the agreement, show that Lupaka was the problem, not Peran. Yet the facts show that Peru is here clutching at straws in both instances. While the 26 February 2019 agreement was encouraging the day it was signed, it proved to be a smokescreen for Peran's bad faith shortly thereafter. Indeed, the Peran community did not lift the blockade on the Laksanga Road at all. Now, this is undisputed. Yet, as can be seen from the screen, point 5 of the agreement is unambiguous that this was required immediately. It says the parties agree that the rural community of Peran will suspend all coercive measures as of this date, which will be ratified by the Community Assembly. Now, the Community Assembly did ratify this, as Mr. Leon testifies. So while the Peran community signed an agreement, it showed absolutely no willingness to comply with it, even if it allowed Lupaka's personnel to access the site for a few days on foot through Peran's precarious road. Now, that's the first point. Now, as to the topographer, referred to at point 4 of the agreement, he or she was to be used, and I quote, to identify and locate the affected land, rural community of Peran. Now, this is in line with Peran's long-standing claim that there was environmental damage on its land, which was discussed during the 26 February 2019 meeting. And at the meeting immediately preceding this as well, on 29 January 2019, as Mr. Bravo has testified. Peran's demand that a unilaterally appointed topographer conduct a survey to build a usable road on Peran's land and to be paid an amount of $9,000 came on 15 March 2019. Now that's 2.5 weeks after Peran still failed to lift the blockade on the Laksanga Road. Lupaka denied that this was the purpose of the topographic survey in the letters to Peran and to the MEM in the following days. Now, despite Peran's unreasonable demand, Mr. Ansley and Mr. Bravo met with Peran officials on 19 March 2019. They offered to consider it and make enhancements on the Peran Road over time. Peru has not made any comment on these conciliatory offers, even though Mr. Bravo referred to them in his witness statements. Peru was also informed about this meeting contemporaneously. In response to Lupaka's offers at that meeting on 19 March 2019, Peran's president demanded that the agreements with Laksanga and Santo Domingo be cancelled, which was of course impossible, and expressly stated that Peran had no intention of lifting the blockade. Again, Peru has not reacted to this. The following day, on 20 March 2019, Peran forcefully re-evicted Lupaka's employees who had recently been allowed on site. Peru hardly refers to this except to say that it was a demonstration or a protest by Peran. Now, just stepping back for a moment, even if Peru is entirely correct that Lupaka's breached its obligations regarding the topographer, and just ignoring that Lupaka offered to abide by Peran's demands, as we have seen, Lupaka's supposed breach could hardly be an excuse for Peran's reaction on 20 March 2019. Its renewed aggression could only have made it patently clear again that Peran would never be willing to negotiate reasonably. Lupaka was not going to continue to spend its time attending sham dialogue meetings after this unless Peran showed some goodwill and lifted the blockade, as it made patently clear. The respondent, in its desperation, places enormous significance on the events of 14 May 2019, by which WDS entered the site. Yet Peru has not correctly portrayed one key detail of these events, and which shows that Lupaka did nothing wrong here. Now let me briefly revisit the facts in relation to this event. The claimant has shown that IMC retained WDS as a plan to secure the site after police had entered the site. Indeed, as testified by Mr. Bravo, the police continued to consider that an operational plan was required, and he and other IMC staff were coordinating with the police to carry it out. The respondent has not contested this. Mr. Bravo obtained confirmation from Colonel Arbulu, the head of the Huacho Police Division, that the plan was going ahead. Again, this has not been contested by the respondent. Yet, on 14 May 2019, the day the police were supposed to intervene and remove the blockade, they did not show up. Again, uncontested. WDS entered the site unimpeded. There were no Peran members at the site of the blockade, as shown by a video shot on that day. Let us see a short clip of this video with Marco Estrada, who, as I said, was IMC's employee, and he's speaking to the interviewer in this video.
Y eso es no, y hemos estado 7 meses. Hoy día justo se cumple 7 meses de la toma.
Muéstrame, ¿qué es esto?
Estas son carpas artesanales, ¿no? Que acá me imagino para visualizar y engañar, para decir que hay gente acá viviendo, han más estas carpas artesanales, ¿no? Entonces cuando venía la policía a inspeccionar, la policía viendo esto pensaba que era un montón de gente, ¿no? Pero en su momento no había personas, ¿no?
O sea, nunca.
So this is the only point that the respondent contests. It ignores the video. Instead, it provides a police report from February 2020 as evidence to support its case that WDS removed 5 members of the Peran community while approaching the mine. Yet the police were not there, so they couldn't have seen this. They did, however, record Peran's account of the event shortly after it occurred. Now, a few hours later, Peran members arrived with full force to the mining site, which, by the way, is not on Peran's land, as we have seen. Peran was shooting their guns, leading to the flee of WDS personnel, as well as Mr. Estrada. They did not return fire. 2 WDS guards were shot, one receiving a bullet wound in the mouth. The next day, another WDS employee was shot dead by a Peran community member. There were no injuries to anyone at Peran. Again, Peru does not contest any of this. To the best of the claimant's knowledge, the police still did nothing in respect of Peran's egregious conduct. Peru states that the incident with WDS forever buried any hopes that Lupaka could have had to enter into an agreement with Peran. That the incident was squarely Lupaka's fault, and that it marked a point of no return in the relations with the community. At least Peru is consistent in this arbitration with the position it took at the time. Yet, it is completely flawed, given the facts that I have just rehearsed. As Mr. Foden demonstrated at the beginning of this presentation, in July 2019, Peran decided to take Lupaka's stockpiled ore at the site. Mr. Leon confirms that he knew that Peran was exploiting the mine during the 3rd quarter of 2019. Furthermore, a few months later, in November 2019, the police confirmed during a site inspection that Paran was exploiting the mine. The police intercepted various trucks loaded with ore that month near the project site. Paran has continued exploiting the mine to the present day, as other contemporaneous documents show, including some authored by Peru's own witness, Mr. Nilton Leon. I will not show you this evidence again in the interest of time. I just wish to refer to the meeting that Mr. Bravo held on 15 July 2019 with Mr. Augusto Cauti, then Deputy Minister of the MEM. During this meeting, Mr. Bravo explained to Mr. Cauti that Paran was already exploiting the mine. In response to which, Mr. Cauti said that if that was the case, he would call the Deputy Minister at the Mininter to ask for a police intervention. Now, Mr. Bravo has testified on this, and Peru has not contested his testimony. Even if late, because this came in July 2019, this could still have been Lupaka's salvation if the police had intervened then. Yet, as we know, this didn't happen. As I noted earlier, the police did intervene on 14 December 2021, after this arbitration was started. Peru points to various other supposed differences in its submission as compared to the situation when Lupaka held the Invicta mine, namely that the intervention in December 2021 has as its objective the closure of the mine, that's stopping Paran's illegal mining activities, and that the intervention did not occur during a period of active state-facilitated dialogue, among other things. Yet Peru's arguments are unsupported by any evidence that this was the true reason for the difference. Indeed, as is clear from the evidence, Paran took Lupaka's ore as from July 2019. And in addition, Mr. Leon has testified that as from the third quarter of 2019, they were actually exploiting. Even on Peru's case, therefore, it is as of this time that the conditions were fulfilled for there to be a police intervention. Yet there was no police intervention until more than 2 years later, on 14 February 2021. By then, it was of course too late. To the best of the claimant's knowledge, Paran continues to exploit the mine, as Mr. Foden said. This puts to rest any of the respondents' arguments that Lupaka's financing agreements are at the root of its loss. Indeed, if Lupaka was still holding title to the mine today, it would be in exactly the same position. Now with that, I come to the end of the factual part, and I will now move on to jurisdiction and the other legal arguments. Just a few words on jurisdiction then. The claimant has established that it has met the standards in the relevant articles of the FTA and the Exit Convention. This is undisputed, except for 2 points that Peru raises. First, Peru alleges that the claimant lost standing by disposing of its investment prior to the initiation of the arbitration. However, as we have shown, the relevant time to assess whether a claimant is a protected investor is when the state breached its obligations. At that time, Lupaka held its investment. In any event, the parties agree that a tribunal would retain jurisdiction in special circumstances. As the Avin and Costa Rica tribunal formulated, even if the investment is lost prior to the proceedings being initiated. Such special circumstances exist where the state's actions and omissions have directly caused this loss, and indeed this is what happened here. Indeed, the state's actions and omissions led Lupaka to be forced to transfer its interest in IMC and the mine to PLI Huaura in August 2019. My colleague will elaborate further on this when addressing causation. In the rejoinder, the respondent states that there is an exception to the special circumstances principle that applies, and hence there is no jurisdiction. It states that Lupaka's subsidiary, Andean American corporation transferred to PLI Huaura not only the shares in IMC, but also all of its rights pertaining to IMC, which it states would include treaty rights. The respondent also states that PLI Huaura is a potential investor under the FTA because of its Canadian nationality. Yet, a private agreement could not affect the rights of Lupaka under the FTA. Also, PLI Huaura would not be able to bring a claim on the same basis as Lupaka, as the breaches would have occurred before its supposed investment, and PLI Huaura would not have incurred a loss under them. Hence, the tribunal should reject this argument. And on this point, I refer the tribunal to paragraphs 6 to 8 of Canada's non-disputing party submission, which shows that Canada is in line with the claimant's position here. Second, the claimant has met all the relevant conditions precedent, including the waiver requirements. Peru alleges that Lupaka should have submitted a separate waiver to file claims on behalf of IMC. This is wrong, because the claimant stands within the scope of the exception at Article 823.5, which is set out at the bottom of the slide. With that, I now move on to the merits. First, on attribution. The applicable principles are found in the ILC articles. Article 4 notes that the conduct of any state organ shall be considered an act of that state under international law. We have just referred to the many actions of and omissions of state organs and government officials over the years. These include the actions of Mr. Retuerto, one of Peru's witnesses, whom you will hear from this week, as well as the actions and omissions of the various ministries and the police. There is no dispute that the conduct of these state organs is attributable to Peru. The claimant's case is also based on the actions of Paran as being attributable to the state. Now, this is because Paran forms a territorial unit of the state, as referred to by Article 4, as we've developed in our pleadings. On this point, Peru invokes inapposite arguments to evade its responsibility. For instance, Peru argues that Paran is an indigenous community which enjoys a special status akin to that of a non-state actor under international law. However, the evidence unequivocally shows the contrary. As you can see in the excerpt at Article C9, the MEM stated that Peru does not meet the criteria to qualify as an indigenous people. Importantly, the respondent in its rejoinder does not contest the correctness of this determination by the MEM. In any event, whether it is an indigenous community or not under Peruvian law, the analysis should focus on a case-by-case assessment of the legal status afforded to the community by the state. Paran qualifies as a territorial unit because it was empowered with autonomous jurisdiction and police authority over its territory. I will come back to these powers in a moment. Peru disputes this conclusion by stating that it was not responsible because Paran was granted full autonomy, yet it cannot evade its international responsibility in this way. Nor can Peru rely on misdemeanor for the proposition that the other state organs could not interfere with the autonomy of Paran as a rural community. To state the obvious, rural communities do not stand above the law. As you can see from the excerpts of Peruvian law on this slide, including Article 1 of the General Law of Rural Communities, like all Peruvian citizens, members of rural communities must comply with Peruvian laws. Moving to the next basis for attribution, Paran's actions are also attributable under Article 5 of the ILC articles. The legal test under this article is undisputed, but the parties disagree whether it was factually met. The first prong requires that the personal entity be empowered by law to exercise elements of governmental authority. Paran and its Ronda Campesina met this requirement as a rural community under Peruvian law. We respectfully invite the tribunal to carefully review the relevant Peruvian legal provisions on the following slides for your ease of reference. Here are a few excerpts from the Constitution at Exhibit C23 and the reference to the General Law on Rural Communities at Exhibit C24, which show that Peran enjoyed wide jurisdictional powers. Such powers are further set out in the General Law on Rentas Campesinas at R116, which also show that Peran enjoys wide administrative and police powers over the territory they control. On the next two slides, you have excerpts from other regulations at Exhibits R103 and C25 and C609, granting jurisdictional and police powers to the Ronda Campesina to maintain peace and security and intervene in the peaceful resolution of conflicts. The following slides focus specifically on the Ronda's police powers, with the regulations on committees of self-defense, for example, allowing them to carry and use weapons in accordance with the law, including shotguns and ammunitions provided by the army. The Peruvian Supreme Court further confirms the special status under criminal law of ronderos when acting within the scope of their authority. In doing so, the decision that's shown on the screen eloquently sets out the scope of the Rondas Campesinas' jurisdictional and police powers, which confirms that they were empowered by law to exercise elements of governmental authority. Now, Peru attempts to minimize the scope of these powers, but this must fail. Peru emphasizes that it did not delegate governmental powers, but merely sought to ensure respect for the relevant community's customs, traditions, and institutions. But clearly, the legal provisions we have just set out go a lot further and show that Peran was granted exceptional powers, which are normally reserved to state organs. Turning to the second prong of the test under Article 5 of the ILC articles, the claimant showed that the community and its Rondas Campesinas were effectively exercising governmental authority during the key for attribution, that is, that Peran's actions are also attributable to Peru under Article 7 of the ILC articles. This article covers acts carried out with ostensible governmental authority. The parties agree that the actions at the heart of this case are illegal under Peruvian law, but Peran's conduct was not so far removed from the scope of the authority granted to it under Peruvian law. Nor can the actions in dispute be characterized as private acts. As a result, these acts remain within the scope of governmental authority granted to Peran. For these reasons, Peru cannot escape the conclusion that Peran's conduct is attributable to the state. I will now turn to Peru's breaches of the FTA. Start with our claim that Peru unlawfully expropriated Lupaka's investment in breach of Article 812. Applying the principle set out under Article 1 on this slide to the facts of the case, this leads to the conclusion that Peran directly expropriated the claimant's investment. Indeed, if you decide that the acts of Peran are attributable to Peru, there is no question that there has been a direct taking. Peran holds the mine even today. And irrespective of attribution, Peru directly expropriated the investment because, similarly to Wiener in Egypt and AMCO in Indonesia, Peru did nothing to prevent the seizure of the mine or restore it to the claimant, despite knowing that its omissions would lead to the loss of the property. Alternatively, Peru indirectly expropriated the claimant's investment. Annex 812.1 provides additional guidance to determine what constitutes indirect expropriation. We will briefly address these factors, which are listed in this article. First, there's been a substantive deprivation of the value of the investment, as well as of Lupaka's rights as an investor. Now, you'll hear from our experts at Accuracy that the value of the claimant's investment was brought to a negative by Peru's actions and omissions. Second, Peru violated Lupaka's distinct, reasonable, and investment-backed expectations. Peru should have disarmed Peran, addressed the illegal marijuana business, ejected it from the blockade, which was on Laxanga's land. Peru should also have ejected Peran from the mining site. Indeed, while there, Peran took IMC's explosives, stockpiled ore, and used machinery to exploit the mine itself. Instead, Peran was given a de facto blanket immunity for all its illegal actions. Third, on the character of the measures, these were unjustified and unreasonable. Peru's intent to promote dialogue and diffuse the conflict is not relevant where the effect of the measure was expropriatory. And finally, we are far removed from any legitimate public welfare objection that are set out in paragraph C of Annex 812.1. Nor can there be any doubt that any consideration given to the possible harm which would be inflicted on Peran if police were to intervene was disproportionate and discriminatory. Notably, considering the other examples where Peru did use force in face of opposition to mining and other projects. We have also shown, and you will hear during the testimonies and examination of the witnesses, that there clearly was a pattern, an entrenched policy decision not to intervene, and therefore to give carte blanche to Peran. As a result, even if you decide against attributing the acts of Peran to the state's actions and omissions form a composite act constituting an indirect expropriation. As to FET, you will have seen the differences in opinion between the parties as to the boundaries of this standard. However, in our submission, you need not make a ruling on the outer limits of the FAT standard, since Peru's treatment of Lupaka's investment fell below the narrowest conception of FET under international law. It is evident that at the very core of this FET standard stands an obligation for a state to enforce its own laws, yet Peru continuously breached these. The claimant is not complaining about individual breaches of Peruvian law, but about Peru's systematic failure to act in accordance with its own laws, and indeed to act fairly and equitably in the circumstances. In response, Peru emphasizes a series of affirmative actions that its authorities took, essentially encouraging dialogue. Yet, this is no response where Peru was asking that the claimant continue to negotiate with a gun to its head, and thus let Peran coerce and harass the claimant in breach of its own laws. Lastly, as to FPS, under Article 805.1 of the FTA, it is clear that Peru breached this obligation too. The same set of facts is relevant to establish a breach of FET and FPS. We would direct the tribunal to our written pleadings here, as Peru has not raised anything new in its rejoinder, save for overemphasizing the state's authorities' wide discretion to decide whether to use force.
I'm not hearing the interpretation. ¿Me escuchan los intérpretes? Hola? Yes, now it's fine. Thank you.
With this, I end my presentation of the legal arguments and hand over to my colleague, Mr. Foden.
Hello again, members of the tribunal. I'm going to now focus on the project's significant economic potential that IMC was on the eve of realizing when Peru breached its obligations under the FTA. I'm then going to address IMC's advanced plans to acquire the Malai plant, which would have increased its daily production from 355 tons to 590 tons per day, plans that were, of course, cut short by the blockade. I'm going to also explain Lupaka's strong capacity to service the PPF agreement both with or without the Malai plant. Now, all of this has been supported by the report submitted by Micon, the claimant's expert on mining operations. You're not going to hear from Micon this week, nor has Peru submitted a report to rebut the evidence adduced by Micon. It's worth pausing here to consider the respondent's curious approach to this crucial expert evidence. See, Peru knows that Mike Khan's evidence is that not only was the project likely to produce significant volumes of gold during a time of high gold prices, but it can't challenge that evidence, and in so doing, it's made two tactical blunders. The first is that it's chosen not to test Mike Khan's evidence via cross-examination. You heard that right. The respondent has chosen not to challenge the technical evidence that fortifies the assumptions made by accuracy in their quantum report. As such, that evidence stands unchallenged. To the extent that Peru relies on AlixPartners, its quantum expert, to challenge mine production estimates, that reliance is seriously misplaced. AlixPartners just simply don't have the expertise to question Mike Khan's conclusions. And while it's one thing not to cross-examine a technical expert, it's another thing altogether not to rebut that evidence with evidence of your own. And that's the second thing. Peru has chosen not to submit an expert report who can undermine Mike Khan's conclusions. Again, that means that Mike Khan's evidence stands unrefuted. Instead, with its last written submission, Peru submitted the legal report of Ms. Dufour, which barely engages with Mike Khan's mining report and shifts Peru's case from one of technical improbability to one full of novel arguments concerning regulatory approval deadlines and permits allegedly outstanding before exploitation could commence. Now, this is remarkably convenient. Peru decided in the last submission to change its case and not meet the claimant's rebuttal evidence head on, but shift the goalposts by bringing in a new expert who the claimant's unable to rebut by adducing similar evidence in the short window between the rejoinder and this hearing, all the while simply moving on from the submissions that prompted the claimant to retain Mike Khan to submit a report in the first place. In any event, Ms. Dufour's report is an exercise in confirmation bias. Peru has simply asked her to come up with timelines for the issuance of permits, albeit timelines that contravene Peru's own laws, to suggest that IMC would not have been able to meet its repayment obligations in time under the PPF agreement. Now, of course, she doesn't say that. She doesn't say that's what her report is for, but it's pretty clear that's what she set out to do. Now, unlike Mike Khan, you will hear from Ms. Dufour this week, because although tribunals often decline to hear from legal experts during a hearing, we consider that her conclusions are particularly cynical, and that's clearly suggested by their belated timing. What's more, Peru's last-minute effort to suggest that its own failure to meet its regulatory deadlines would have meant that Pandian would foreclose on its agreement with Lupaka suffers from a lack of commercial sense that is often typified of respondents in these proceedings. If Peru considers that a lender would rather refuse forbearance on a lucrative gold streaming loan agreement because of permit delays that would last a few weeks, months, maybe even a year, in favor of proceeding on foreclosing on a debt for pennies on the dollar, then you also have to take its quantum submissions on the but-for scenario with a grain of salt, because they're just simply out of touch with commercial reality. Also, Ms. Dufour's conclusions just ignore the facts. The claimants established that when Peron set up the blockade, IMC was operationally ready to commence mining. Now, as Mr. Ellis explained in his witness statements, by early October 2018, IMC had all of its mining infrastructure in place and had excavated at the 3,400 meter and 3,430 meter levels, and had even identified the stopes that it intended to blast first under its mining sequence. Of course, these allegations too have to be accepted by the tribunal, because the respondent has remarkably chosen not to cross-examine the claimant's lead witness, Mr. Ellis, who's at the end of this table.
So I've never seen a slide like that, I must say.
Now, we've spoken before about tactical blunders, but in my 15 years of practice in international arbitration, I've never seen a respondent choose not to examine the chairman of the claimant company. As an advocate, I hanker for opportunities to cross-examine chairmen and CEOs. Our friends don't seem to share that similar affinity. But we can all surmise the reason for their reluctance. They know that Mr. Ellis is a vastly experienced and successful mining executive with a credible story of an earnest foreign investor that was bullied by a local municipality without any assistance from Peru, notwithstanding its obligations under the FTA. In short, the respondent knew that Mr. Ellis's testimony could hurt them, so he's not here, even if he is here. Now let me guide you through the geological data that supports the project scope, which of course didn't become a reality because of the blockade. In 2012, prior to actually acquiring the project, Lupaka obtained an NI 43-101 mineral resource estimate from SRK. We call this the 2012 SRK report. Now, you might be familiar with it, but NI 43-101 is the name of the Canadian regulation that governs the reporting of mineral resource estimates and exploration results. They come in the form of a really lengthy technical report. And because the purpose of the Canadian regulation is to protect investors from potentially misleading reporting, those reports have to be prepared by an independent, qualified consultant, and those consultants are operating and issuing that report under potential civil or criminal penalties for misstatement. And the preparer of this particular report, SRK, is arguably, the world's foremost mining consultant, and it's an industry leader by reputation. The 2012 report showed that the primary mineralized zone was located in what's called the Atenea vein, and it had a mineral resource of 5,827 kilotons with an average grade of 3.89 of gold in the measured and indicated categories. Now, as explained by Mr. Edwards in his witness statement, that report noted that the overall gold recovery was 84.8%. This recovery rate is very high, and it aligned with previous independent studies, which, of course, made this project very attractive. Of course, you won't hear this from Mr. Edwards this week because, again, the respondent has forfeited the opportunity to examine him. Now, as I believe Mr. Velarde explained, in 2014, the claimant made the strategic decision to reduce the scope of the project from 5,100 tons per day to 355. And it was going to outsource the processing of the project's ore to a third-party processing plant. And on that basis, the claimant obtained a preliminary economic assessment, a PEA, again from SRK, and this was in April of 2018. Now, a PEA is a study that includes, amongst other things, an economic analysis of the potential viability of a project's mineral resources, and it takes place typically before a feasibility study. The PEA helps mining companies understand the risks and the uncertainties associated with a mining project, and it helps move them along towards an investment decision. The 2018 PEA relied on the 2012 SRK report, but it also relied on contemporaneous bulk sampling results from the Atenea vein. The results of that PEA were highly promising. It confirmed the mineral resource estimates that SRK had established in 2012, and it concluded that the project was not only of, quote, considerable merit, but also that gold could be economically extracted. In 2018, the claimant went and hired a company called Red Cloud. Red Cloud is a Toronto-based consultancy and investment bank, and it focuses primarily on junior mining companies. It updated the 2018 PEA to reflect an increase in production capacity to 590 tons per day based on the prospective purchase of the Malai plant. Now, as explained by Mr. Castaneda in his first witness statement, the Malai plant was a nearby and relatively modern plant, and it had a capacity of 600 tons per day. The Red Cloud model therefore envisaged a higher production rate compared to the 2018 PEA, lower unit processing costs, an in-house processing plant, and significantly lower transport costs. Now, since the Red Cloud model wasn't supported by a detailed mine plan, in these proceedings, the claimant has gone and engaged that consultancy Micon to perform a detailed review of all of these underlying documents and assess independently the various inputs into Accuracy's DCF analysis. In many ways, Micon's report serves as a feasibility study because the claimant did not do a feasibility study. Instead, it relied on the PEA and the Red Cloud model. Now, I say this because Micon developed an updated mine layout, a development schedule, and a production plan that identified the specific sections of the resource that were to be mined in each year under this 590 ton per day scenario. This is what mine engineers typically do in a feasibility study. Micon's update to the Red Cloud model confirmed the feasibility of a mine plan for 590 tons per day. It extended the production schedule from 6 to 10 years, and it raised confidence in the resulting production plan and cost estimate to a level that was comparable with the 2018 PEA. Now, as explained earlier, the claimant's primary position is that the acquisition of the Malai plant would have allowed it to reach this operational capacity of 590 tons per day. And as you'll see this week, the evidence on record corroborates that Lupaka would have acquired the Malai plant in March 2019, but for the blockade. Now, you're going to hear Peru label the claimant's acquisition of Malai as hypothetical, but the evidence shows differently. The claimant effectively needed two things to finalize its acquisition of the Malai plant. First, it had to finalize the draft agreement with the then owner, Buenaventura. And second, it had to get funding for the purchase. And both of these tasks were within hand. By the time of the blockade, Buenaventura and Lupaka, through IMC, had agreed on the terms of a ready-for-execution draft Malai purchase agreement, which reflected a purchase price of $10.4 million plus VAT. What's more, that purchase agreement actually granted the claimant the right to process up to 8,000 tons per month at a rate of 600 tons per day from the signing of the agreement through the close of its transaction. So they could have used Malai before they were even had finished the deal to buy it. Now, concurrently, Pandian, the lender, and Lupaka had agreed the final terms of the amendment and waiver number 3 to the second amended and restated PPF agreement. We just call this the draft amendment to the PPF agreement. And that agreement was going to fund the Malai acquisition. At the closing of the purchase agreement, Pandian was going to unlock a further tranche of the loan for approximately $13 million. And it would have granted Lupaka a 9-month extension during which no gold repayments were required. Now, this ready for execution amendment is not just for the Malai purchase. It's significant not just for the Malai purchase, but it's also demonstrative of Pandian's willingness to be flexible about repayment terms where its economic interests were going to be served. And I'm going to return to that point shortly. Now, as explained by Mr. Ellis in his second witness statement, Pandian, Buenaventura, and Lupaka had all agreed that they would sign the two agreements on the 15th of October 2018. That date should resonate with you because it's the day after the blockade went into place. Indeed, Lupaka had board approval to do just that. They were going to issue a press release the very next day. The only outstanding steps to close the Malai purchase agreement was for Buenaventura to obtain the formal approval of the Malai community to transfer the surface rights to Lupaka. Now, despite some delay due to the renewal of Malai's governing committee in the community, the Malai's community consent was finally approved and granted in March of 2019. So, as you can see, the deal for Malai would have gone through but for the blockade. Indeed, Buenaventura expressed its disappointment with the blockade and Lupaka's resulting inability to follow through with the deal. Now, since Lupaka had obtained the Malai community's consent in March 2019, This meant that the first gold repayment would have been due in January 2020. Now, you're going to hear Peru say that Schedule P2 to the draft amendment to the PPF agreement provided for Lupaka's gold repayments to start in September 2019. Our friends opposite, their view is that even if the Malai transaction would have crystallized following the community's consent, the claimant would have equally defaulted on its repayment obligations. Now, this is just wrong. Peru's theory doesn't make any commercial sense. Pandian would have benefited far more from implementing the PPF agreement than from enforcing its rights and selling the debt. No matter what Peru says, Pandian was supportive of the project, and as a financial institution, it had no interest in taking over IMC and operating the mine itself. Now, as you can see on the screen, and as I mentioned moments ago, Pandian had shown a similar degree of flexibility in the past with respect to other obligations under various iterations of the PPF agreement. And there's no reason to believe that this forbearance wouldn't have been present in the face of mere short-term delays to obtaining certain approvals or permits, as Ms. Dufour suggests. As you saw earlier, Pandian only sold its interest in PLI Huara in July of 2019. That's 9 months after the blockade. And that's the point at which it saw that there was no hope for the occupied and inaccessible Invicta project. Let's now turn to the terms of the draft amendment to the PPF, which again would have been in place but for the blockade. Now, as you can see on the screen, Lupaka's gold repayment obligations under the draft amendment would have increased from a total of 64,630 ounces to be repaid by November 2023. Now, as forecasted by Micon, Lupaka had to mill a minimum monthly tonnage of 7,200 tons per month during the first 4 months and 11,343 tons per month at its peak to meet the obligations under the PPF. Now, with the Malai plant, Lupaka would have met those obligations with plenty of room to spare each month. Both of the targets were readily achievable. And even if ore processing at the Malai plant was delayed, Lupaka would have been able to meet its payment obligations by engaging a third-party processing plant, or even simply paying Buenaventura to process ore at Malai before the purchase was completed. The claimant had also entered into a 1-year contract with Huancapeti II, which is a nearby processing plant, to which it started to already send large shipments of ore right before the blockade in October of 2018. And as I just mentioned, it was making arrangements to already process ore at Malai before it took ownership. You're going to hear Peru say that the claimant's problems with potential ore processing options were insurmountable. Well, to steal a phrase from the Profumo affair, they would say that. But it just doesn't make it true. As explained by Mr. Castaneda in his witness statement, it's normal to identify obstacles and risks at the outset of processing operations, and in any case, Lupaka could have solved any technical issues by refining internal procedures without incurring high cost or further delays. What is more, in order to secure adequate toll processing capacity and give a margin for potential contingencies, Micon has conservatively provided for a 3-month ramp-up period in which the production schedule increased gradually, in line with the claimant's gold repayment obligations under the PPF agreement. Lastly, even if the claimant wouldn't be able to meet the initial production schedules, and that Pandian, for some economically irrational reason, insisted on immediate repayment, the claimant could still make those payments in cash rather than physical gold if necessary. Indeed, the claimant had a very strong track record of raising financing, and Mr. Ellis set out that track record at a table in his witness statement. Now, Peru's experts, Alex Partners, they tried to undermine the claimant's ability to raise capital by relying on an example from March 2019, where the claimant only obtained 66% of the capital raise it was seeking to perform. Now, the tribunal will note that this attempt to raise financing happened 5 months after the blockade, when the claimant had no access to its own project. Good luck to anyone trying to raise capital in those circumstances. The claimant's ability to raise financing before the blockade, though, shows a different picture. Between March of 2014, when the claimant shifted its focus to this project, and until May of 2018, when the last round of financing took place before the blockade, the claimant hit 102.67% of its fundraising goals through both debt and equity.
Mr. Foden, sorry to interrupt. I am informed that the remote transcript is not working.
Yeah, I have to circulate a new link, but I didn't want to interrupt.
Sorry, I'm not clear where we are. So do we have remote transcript or not?
We do, sir. The link shifted between the one that I had circulated and the one that is being used at the moment, so I'll circulate it in a moment. But the transcript is working in the room, so.
Okay, all right.
Ms. Torres, do you have an estimate of how long it will take to determine whether we just continue and then we fill the gap or we pause?
The transcript is working right now for the room, and it'll take me a minute to
Okay.
go and circulate the link to you.
We don't want to interrupt claimant's presentation, so I think that we can continue.
Thank you, Patricio. So the claimant's ability to meet its fundraising goals makes sense. Investors in TSX companies are practically salivating to invest in projects that are on the verge of production, as was the case with Invicta. Now, Peru makes like 2 further attempts to dismiss the reliability of the geological data and the production forecasts, and these are equally baseless. You're going to hear Alex Partners question the reliability of the average gold grade assumed in the 2018 PEA. Given the low gold grade observed in some of the pre-development material that the claimant obtained in October of 2018. But this criticism is very misplaced. In the first instance, it lacks credibility. Alex Partners are just unqualified to opine on matters of gold grade. Had Peru gone to the trouble, as the claimant did, of appointing a mining expert to provide such input, perhaps that criticism would bear some weight. But Peru chose not to do so, and this tribunal has to be pretty leery of a testifying valuation expert getting out ahead of their skis on issues of metallurgy. Alex's partner's lack of expertise in this area is particularly laid bare by the rather simple explanation, untested explanation, that Mr. Ellis provides in his witness statement, where he states that there was nothing surprising about the fact that the anticipated gold grade under the 2018 PEA was higher than the one found during the pre-production phase. That's because the 2018 PEA was derived from ore samples that were representative of the entire deposit to be mined, whereas those samples in October 2018 relate to pre-development material that wasn't necessarily extracted from the stopes that SRK had set out to be mined. Put simply, Peru points to grades based on ore that was pulled out of the mine when they were digging tunnels, rather than ore from the actual ore body. You know, a resource geologist would be fired for making such a schoolboy error. Now, you're also going to hear Peru say that Micon's extended production period was never considered before, and in any case, it was beyond the approved mining plan. But Peru, again, misses the point here. As explained earlier, Micon's extended production schedule is actually based on the measured and indicated resources defined in SRK's geological block model and contemporaneous reports. By contrast, the SRK and Red Cloud studies had no bearing on the optimal mine plan that the known resource could actually support. Now, compared with the 2018 PEA, the higher production rate in Micon's report results a lower cost per unit, allowing for the application of a lower cutoff grade, which then, consequently, leads to greater volumes of economically profitable material. The net result is a 10-year lifespan of the mine. Now, put simply, absent the blockade, the claimant could have continued to explore and expand the mineral resource base, which would have likely resulted in an even longer mine life. This, of course, is relevant to determining the fair market value of the project. Now, Peru doesn't contest the project's mining potential or the technical possibility to extend the life of the mine as per Micon's report, and it can't contest those findings because it didn't appoint an expert to do so. It's with that I'm going to hand it over to Dr. Veit to discuss the claimant's case on quantum, but I did notice that it seemed like there might be a suggestion that we need their 5-minute break.
Yeah, I think that would be appropriate. And then when we come back, if we could have just a very brief indication from the claimant of what they say we should do about the DeFore report. We were told in an earlier presentation that we should disregard it. Is that the position, or is it? I detected a slightly more nuanced position recently. So if you could just clarify that for us when we come back.
We'll
All right.
Happily address that, sir.
All right. It's 12:28. Let's be back at 12:29. Let's be back at 12:34. And I'd invite you not to leave the room for this short break unless you need to. Okay, are we ready to resume, respondent?
We are, sir. To address your question, Mr. President, we would ask this tribunal to disregard Ms. Dufour's report. And should it issue a ruling to that effect, we will opt not to cross-examine Ms. Dufour.
Mr. President, may I? We would, of course, it comes as no surprise, object that request. And if what claimant is asking the tribunal to do is make a ruling in the context of this arbitration, we would like to be heard about that. I'm sorry, in the context of this hearing, we would like an opportunity to be heard about that. We would object that request, and also we would make submissions in regards to the introduction of the MICON report with the reply. Thank you.
Understood. We don't propose to make any ruling right now. I'm simply trying to clarify what the situation is. And it's been clarified, and the tribunal will consult and determine how to go forward. All right, back to claimant's presentation. Just to check with the secretary that how much they have remaining of their 3 hours?
About 37 minutes,
Okay, then thank you.
36 and a half.
Thank you. We'll now turn to quantum. But before getting into the actual quantum of losses, let me deal with the question whether or not Peru's acts and omissions caused the claimant's loss and whether the claimant contributed to its losses. You will hear Peru say this afternoon that it has not caused the claimant's loss for various reasons, but a quick look at the legal standards for causation resolves this issue in favor of the claimant. As you know, under Article 31 ILC, the responsible state is under an obligation to make full reparation for the injury caused by the wrongful act. The commentary to this Article 31 explains that there needs to be a finding of factual and legal causation. To establish factual causation, the tribunal should use a but-for test. The question the tribunal needs to answer is whether Lupaka would have lost its investment but for Peru's wrongful conduct. To establish legal causation, the loss must not be too remote. It must be proximate to the state's conduct. Simply put, the tribunal needs to decide whether the claimant's loss was a normal and foreseeable consequence of Peru's wrongful conduct. Lupaka established that the loss was approximate, caused by Peru's breaches. Now, this creates the rebuttable presumption that causation is established. This then shifts the burden of proof to the respondent to prove that the intervening event, which could break the cause of the chain of causation. However, Peru failed to do so. The chain of causation in this case is very simple. Lupaka lost access to its mine due to Paran's blockade and Peru's failure to reinstate Lupaka's possession of its mine. This was the factual cause of the claimant's loss. But for the blockade and Peru's failure to act, Lupaka would have been able to access the mine and extract ore. However, as it was not able to do so, the claimant defaulted on the repayments under the PPF agreement, and PLI Waura foreclosed on the IMC shares. Now, Lupaka's loss of its investment was a normal, foreseeable and proximate consequence of Peru's wrongful conduct. Peru failed to establish that any of its alleged intervening events broke the chain of causation. We'll get into those in a moment, because you will hear Peru argue that those were all attributable to Lupaka, and hence Lupaka contributed to its loss. But first, let us briefly go over the legal standards for finding contributory fault. To establish the investor's contributory fault, the investor's conduct needs to be willful or negligent, and there needs to be a material and significant contribution to the loss. The parties agree on the first limb of this test. Peru, however, denies that the contribution needs to be a material, even though it acknowledges that this requirement is stipulated in the ILC articles as well as in case law. Now, to the facts of the case. Peru asserts that 5 causal circumstances have either broken the chain of causation or they amount to contributory fault by the claimant. Neither of the assertions are correct, and we'll now look at them in turn. First, Peru argues that the claimant is to blame for the loss of its investment because it did not obtain a social license. According to Peru, it is Lupaka's fault that the Peruvian community acted illegally and that Peru did not reinstate law and order. First, Peru says that it was the claimant's breaches of its own obligations under the social management plan that incited Peru's illegal behavior. This is wrong. However, even if the claimant had breached the previously approved social management plan, it could have been sanctioned by UEFA according to the laws and not left by itself in the face of Peru's criminal behavior. Second, as you have already heard, the claimant was under no obligation to obtain Peru's agreement to continue with the exploitation of the mine because the project was not on Peru's land. Peruvian law only required the claimant to reach an agreement with the communities of Laxanga and Santo Domingo, which it did. Third, even though the claimant was not obliged to reach an agreement with the Peruvian community, it did conduct negotiations in good faith. Alas, the negotiations were futile because Peru continuously demanded more from the claimant, seemingly being uninterested in a reasonable outcome from the parties. The unsuccessful negotiations with Peru were not the claimant's fault and cannot amount to contributory fault or an intervening event breaking the chain of causation. Peru's second argument is that the claimant's pledge of its investment as a loan collateral amounted to an intervening event which broke the chain of causation. Again, this is not true. First, the claimant's investment lost the entirety of its value as a result of Peru's blockade and Peru's failure to restore the claimant's access to the mine. Peru compares the present case with Inversión y Gestión de Bienes versus Spain. However, in Inversión, the claimants willfully stopped making mortgage payments, knowing what the consequences will be. In Lupaka's case, the pledge of its investment as a loan collateral is standard practice in the mining industry. And more importantly, Lupaka did not willfully default on repayments. It simply could not make repayments as Peru destroyed the investment. As we just discussed, PLI Huaura's foreclosure was a foreseeable consequence of Peru's wrongful acts. It occurred after, and more importantly, because the claimant lost the entire value of its investment. Even the respondent acknowledges that the default events listed in PLI Huaura's notice of acceleration primarily related to the blockade. Peru nonetheless continues to argue that even in the but-for scenario, Lupaka would have defaulted under the PPF agreement. Fantastically, it makes this argument for two of the events which occurred directly due to the blockade. But as Mr. Ellis explains, PLI Huaura would not have foreclosed because of the remaining events of default, which contain mainly reporting obligations with which Lupaka materially complied at all relevant times, and then previously waived requirements to have a mineral offtake agreement in place. Mr. Ellis is here with us today, but Peru doesn't cross-examine him on these and other material facts. Now, the next argument that you will hear from Peru is that outstanding regulatory approvals in October 2018 were the claimant's fault, and that this contributed to or even caused the claimant's loss. Peru bases these arguments on the expert report of Ms. Dufour. But even if Ms. Dufour's opinion were correct, the outstanding approvals would not destroy the entirety of the investment. At worst, they would have slightly delayed production. However, as Mr. Foden explained, the optimistic scenario set out by Ms. Dufour would allow the claimant to start making repayments in January 2020, which is the date when the first repayments were due under the third amendment and waiver of the PPF agreement. The third amendment allowed for a 9-month grace period for repayments after my purchase agreement was signed. Had the deal closed in March 2019, Lupaka would only have been obliged to start with the repayment obligations in January 2020. Peru's last argument on causation is that Lupaka did not have satisfactory ore processing capacity to make its repayments under the PPF agreement. Again, this allegation is not true. Even taking at its highest, Peru's argument would only affect quantum rather than causation. The alleged lack of processing capacity is not an intervening event, even capable of destroying the entire investment. And as Mr. Foden has explained, the claimant had a number of very good options for processing ore. The Mayai plant or the third-party ore processors with whom the claimant already contracted. Instead, but for the blockade, Lupaka would have proceeded to extract the ore, processed it at its Mayai plant under Buenaventura's ownership or the third-party processors, and continued processing the estimated tonnages itself once it had fully acquired Mayai. But even if using the Mayai plant and the third-party processors were not possible during the relevant period before Lupaka acquired the Mayai plant, Lupaka would have easily been able to repay any shortfall in cash. Lupaka could have made the initial repayments by processing only 30 tons a day of ore, or less than 3 days of full production, or by raising funds, which it has previously done successfully, as Mr. Foden has shown. And as Mr. Ellis has explained, Pandion would have been willing to reschedule the repayments until the claimant was able to meet them because it supported the project. Peru's assertion that the actual turn of events proves otherwise is without base. Pandion only sold its interest in PLI Huaura when it no longer saw any hope for the occupied and inaccessible project. To conclude on causation and contributory fault, none of the 5 alleged intervening causes broke the chain of causation or constitute contributory fault. Therefore, the claimant needs to be compensated for its losses in full. Next, you will hear Peru argue that the claimant is claiming compensation for its business plan, which is not a covered investment according to the FTA. It's a position that Peru developed in its rejoinder after alleging that Lupaka is claiming compensation for the Mayai plant as a prospective investment. Now, with all due respect, this is nonsensical. Lupaka is not asking to be compensated for the expropriation of the Mayai plant or for the business plan itself. The Mayai plant acquisition simply supports the claimant's business plan, in which the claimant was able to process ore at 590 tons a day, which is the basis for the but-for scenario put forward by the claimant. To assess the damages, the tribunal will have to decide which business plan to consider as the basis for the claimant's counterfactual scenario. For that, the tribunal should use the but-for test supported by contemporaneous evidence before the breaches of the FTA, consistent with the Limmeyer and Tessian jurisprudence. And as you will see over the course of the next few days, but for Peru's failure to remove Peru's blockade and reinstate the claimant's possession, Lupaka would have acquired the Mayai plant and processed ore at 590 tons a day. Now, let's turn to the actual valuation of Lupaka's investment. Accuracy assessed the claimant's damages at 41 million for the 590 tons a day scenario as at the valuation date plus interest. Alternatively, the damages for the 355 tons a day scenario amount to $32 million plus interest. The parties agree that the DCF approach is the appropriate valuation method for pre-production mines, such as the one at hand. However, they disagree on a number of input variables and assumptions. AlixPartners identifies what it calls 4 fundamental flaws in accuracy's analysis. The 4 flaws advocated by AlixPartners, however, are mostly another iteration of Peru's ill-formed causation arguments. Most importantly, the 4 fundamental flaws are instructions on which Ms. Kunzmann relies, not facts or opinions within her own expertise. The first 2 relate to the dispute with Paran, namely whether the police intervention would have resolved the problem and whether the claimant needed to obtain a social license. We have been to that, and Mr. Gallego has explained how Peru would have gotten rid of the bandits and criminals from Paran and should have restored law and order. The project was not on Paran land, so there was no need for Lupaka to reach an agreement with the Paran community, even though it did negotiate in good faith, as Mr. Velarde has explained. The third alleged fundamental flaw is that, but for Peru's breaches, the claimant would still have defaulted on the PPF agreement due to a poor performance of operations. As we've discussed earlier, this is not the case. Finally, Peru's alleged fourth fundamental flaw is that Accuracy disregarded financing risk. Now, as Accuracy explained, this financing would not be needed to settle debts owed to PLI Huaura, because in the but-for scenario and absent the blockade, the claimant would have been able to start production in time and thus repay the PPF agreement in installments based on the agreed schedule. Now, in relation to the financing of the Mayai plant, the claimant's intention was clear. It would have obtained the additional financing from PLI Huaura needed for the acquisition, and indeed, it had already finalized the third amendment to the PPF agreement to that effect in October 2018. Now, Accuracy updated its valuation for both scenarios based on Mycon's analysis and AlixPartners' comments on the operational and technical assumptions. First, Accuracy adopted Mycon's revised start date for commercial production, which Mycon confirmed to be November 2018. This revised start date, regardless of Peru's allegations, is realistic as contemporaneous evidence shows. The claimant was operationally ready to start production immediately before the blockade and had various options for processing its ore. Accuracy further adjusted its valuation on Mycon's review of the relevant data that showed that the claimant would have operated the mine for 10 years. Peru's quantum expert claimed that Mycon was wrong, but as Mr. Foden highlighted, Peru did not provide a technical mining expert that would have been able to review the data and opine on the extended production schedule. Accuracy further adjusted the ore grades using Mycon's input. Now, Mycon explains in their report the reasons for the anomaly in gold grades experienced during the 2018 ramp-up period, and that it is likely that the grade shortfalls would have been overcome in early 2019. In addition, supervising the ore processing would allow for higher recovery. This would not have been a financial impact on the claimant, as the processing would be done in-house at the Mayai plant, which the claimant would own but for Peru's breaches. Accuracy then increased average operating costs to account for various additional expenses identified by Mycon and AlixPartners, and it also adopted its model to Mycon's estimate for capital expenditure. Finally, Accuracy decreased the discount rate in line with a lower project-specific premium that it applied in light of Mycon's report. Accuracy and Mycon both consider the project to be at feasibility stage. Even though the claimant never obtained a formal feasibility study, it did not need to do so because its access to mineralization largely reduced a key geological risk. Additionally, feasibility studies are necessary for financing, which the claimant already secured. So the claimant also materially completed all development works and was ready to start production before the blockade. However, as explained, and due to the uncertainties in the red cloud model for the 590 ton a day scenario, Accuracy initially adopted a higher project-specific premium in the first report. Accuracy then reduced this premium on the basis of Mycon's mine plan. Mycon concluded that the certainty of the 590 ton a day scenario equals that of the 355 tons a day scenario, and that the same discount rate was appropriate. As a result, Accuracy decreased the project-specific premium in line with the appropriate premium for projects at feasibility level. Now, AlixPartners further complain why or that accuracy did not account for social license risk explicitly. Again, there was no need to obtain Peron's agreement to continue and exploit the mine, but if AlixPartners was referring to a general social license risk, which Peru alleges has not been accounted for, then this general risk for a social license is included in the Peru-specific country risk premium. This country risk premium accounts for additional risks of conducting business in Peru when compared to other risk-free jurisdictions.
Excuse me, Counsel, can
Yes.
you recall off the top of your head, what was the risk premium they used? If not, we'll look it up.
The country risk premium, I'm sorry, I can't
That's
recall
fine,
that.
we'll look it up. Thanks.
The project-specific risk premium was, however, 3.3%. Peru claims that any compensation owed to the claimant should be reduced by the 13.3 million, which was the residual value of the claimant's investment. Now, this is incorrect. PwC in August 2019 valued IMC at $13.4 million US dollars, but excluding the debt owed to PLI Waura. This valuation was made by PwC to determine whether the value of IMC's pledged shares exceeded the 15.9 million US dollar debt which the claimant owed to PLI Waura, which was not the case.
Counsel, would you please remind us if this loan was with or without recourse? The loan to
The PLI Waura loan. Well, that was the loan that
the loan that was given on the pledge of the shares. Was it with or without recourse?
recourse in what sense?
In the sense that if the value of the shares is not enough to pay the debt, if the loan is without recourse, that ends the transaction, and so the debtor doesn't owe anything else. If it is with recourse, then the debtor is still obligated to pay the difference.
Yes, there was a dispute on that, and to the extent I understand, that question was settled between Pendian and Lupaka after the pledge was foreclosed and sold.
And there was no further recourse
There was no,
as a result
exactly,
of the
there was no
settlement?
further recourse.
Okay, thank you.
Now, ignoring the net value of the claimant's investment, or to put it the other way, just to finish that off, comparing the 15.9 million of debt with the value at that time of 13.4 million, the value of the claimant's investment was nil because it was without recourse or negative. But ignoring the net value of the claimant's investment, you will hear Peru argue that PLI Waura's foreclosure means that the investment held value. This is wrong. Lonely Mountain wanted to operate the mine itself, hiring Mr. Goyuzeta, who believes himself to be the best placed person to operate and extract value from the project. However, as we heard this morning, Peron continues to illegally mine the claimant's project, and Lonely Mountain was ultimately proven wrong, as it is still not able to access the mine. To test the damages assessment at the valuation date, Accuracy compares its DCF-based valuation to 4 different indicators of value. First, Accuracy finds that using a market capitalization approach leads to an illustrative valuation in the but-for scenario of $33.4 million US dollars. Accuracy simply extrapolated Lupaka's market cap from 25 October 2018 onwards, using a junior gold miners index plus a control premium. As you can see in the chart before you, Lupaka's share price and the index showed a significant correlation, at least until late 2017. And even if one were to assume that an underperformance of Lupaka's share price compared to the index from March 2018 onwards, when Lupaka announced that it no longer held the Josni Toro project to October, was permanent, and you see that in the I've highlighted this period in green on your chart in front of you. Even if one were to assume that this underperformance was permanent, the indicative market cap would still amount to some $28 million US dollars at the valuation date. Now, this market valuation is in line with Accuracy's estimate of the fair market value of the Invicta project in the 355 tons a day scenario, and quite a bit below the 590 tons a day scenario. Why is this? It is because the claimed share price at the time would not have reflected the additional value of the project, which would have resulted from the MAIAI transaction that was not announced to the market at that time. Second, Accuracy looked at Lupaka's sunk cost incurred between the acquisition date and the valuation date, and applying interest as a proxy for the expected minimum return on the basis of the implied interest rate in the PLI loan. Accuracy's sunk cost assessment resulted in a value of $43 million US dollars. After deducting the debt under the PLI loan of $15.9 million, Accuracy finds a benchmark for the project at $27 million US dollars. This is again lower than Accuracy's assessment of the 590 tons a day scenario. And while sunk costs may not be an appropriate valuation for pre-production properties, sunk costs can certainly serve as a minimum floor for the valuation. Now, the third cross-check is based on transaction multiples. Accuracy used 26 transactions valued at over $1 million US dollars for a controlling stake for companies in the gold industry, and which closed within 5 years before the valuation date. Based on the transaction multiples, Accuracy arrived at the post-tax NPV of $33.3 million under the lower scenario and some $47 million US dollars under the 590 tons a day scenario. Excuse me, which is very close to Accuracy's primary valuation. Finally, Accuracy looks at other contemporaneous evidence of valuation, specifically the Red Cloud model and the SRK PEA mine plan for the 355 tons a day scenario, and the Red Cloud for the higher scenario at 590 tons a day, which both produce significantly higher values. But let's just reflect for a moment. What if Lupaka had kept the mine, taking into account actual metal prices over the last 3 years and taking into account hindsight? The fair market value of the project as of today would have been over $85 million US dollars. Again, we are not claiming the 85 million, but it shows how conservative Accuracy's assessment of Lupaka's loss is at 41 million US dollars plus interest. And the tribunal should have no hesitation to award this amount to the claimant. Now, lastly, let's look at pre-award interest. I know that tribunals think interest is not the most interesting of topics, so in the interest of time, I'll keep this brief. Under Article 812, paragraph 3 of the FTA, interest needs to be paid at a commercially reasonable rate. The claimant in its memorial put forward LIBOR plus a margin of 2%, compounded annually as commercially reasonable, and the respondent's experts seem to agree. However, as LIBOR will no longer be used from June 23 onwards, AlixPartners presented two alternatives: a 1-year US Treasury bill, UST, or a 180-day moving average based on the secured overnight financing rates, the SOFR rates, both with a 2% premium. Now, UST and SOFR are not comparable with LIBOR, nor are they commercially reasonable rates as required by the FTA. The two interest rates, unlike LIBOR, are risk-free rates. One therefore needs to apply a credit spread of at least 1% to account for the additional credit risk that you would compensate in LIBOR. In addition, the current market conditions have significantly changed over the last 2 years, with inflation rates hitting a 40-year high. For the last 20 years, these rates offered in the rates offered in the interbank market in LIBOR closely followed the low inflation rates. However, as you can see in the chart before you, LIBOR has become decoupled from inflation since 2020. As a result, even LIBOR plus 2% would be significantly below the current inflation rate. The same is true for the two interest rates that Peru relies on. Applying LIBOR plus 2%, or even more so SOFR plus 2 or UST plus 2, would result in a negative real interest rate, which incentivizes Peru to delay any payment of the award, as the value of an amount owed to the claimant would decrease over time in real terms. Therefore, the claimant has instructed Accuracy to recalculate pre-award interest based on LIBOR plus 4%, which is more in line with the current inflation rate. And if LIBOR is discontinued whilst compensation to the claimant is still outstanding, an interest rate based on UST plus 5% should be used. As shown in the slide before you, both these rates closely follow the inflation rate. Additionally, LIBOR plus 4, or an equivalent UST plus 5%, is consistent with the past arbitral practice, even in a low inflation environment. You can see this from the examples on your slide. And that, members of the tribunal, concludes our opening statement.
Thank you, counsel. Let me ask whether my colleagues have any questions. Yeah. I'm not seeking an answer now, but I would invite you to reflect, because I'm wondering how this hypothetical well-informed future borrower, of the basis on which that well-informed future purchaser rather should assume that they would be able to carry forward the business free of any social interruption. Is the premise that Peru would, going forward in the future, do whatever is required, whenever is required to assure that result? Is that the premise?
Yes, Mr. President, that's the premise. The premise is that Peru would reinstate law and order and see to it that law and order can be maintained, as any government would do.
In that case, if there are no further questions, any administration we need to tend to?
No, sir.
All right. Well, we're scheduled for 40 minutes, so we're running just a bit ahead of schedule. So let's resume at, I have to do the math here.
148.
140, I was going to do 147, but 148. Let's resume 148. Okay, we'll see you then.